Yes. Oh, okay. Yes. Yes.
I get them for one, you are not like you are not.
We don't know. No. It will be called. Yes. Not sure. Huh? What is the budget? What is the urgency? Urgency. When did you file? We have not granted stay in similar cases for your information. For your satisfaction, we will have all at tomorrow. Yes, please. No, we have stopped that practice. We have received so many complaints that people behind the back of the other council have got the matter settled. Yes. Stop, it will be called. Yes. Yes. No, only fine of 25,000 has been imposed on you. Nothing beyond that. Yes. Then this is the number two. She in fact reduced 4 times. Right. And then she has been residing with this. You must have obtained handing over possession. There is acknowledgement of handing over possession in July 22. To whom you handed over? She actually left the because your lordship is allowed election respondent is also process. They are all relatives. So there has to be an acknowledgement like this. Who will believe inside? Your lordship, now the document will be handed over to your possession. Now no one is staying here. Actually, that's the problem by filing a claim petition that created the whole issue. Lordship, she is also actually.
No. So you handed over to the possession to whom? According to you in July 2022.
She left, your lordship. She left the premises.
Didn't hand over.
She left the premises.
When?
In July 2022.
July has 31 days. 31 days. July has 31 days. So on some day, all days she left possession and all days 1st July to 31st.
In proof of her leaving, I have filed the document saying that she has been residing with her.
Anything else apart from this plea of handing over possession?
And now it has been vacated and
Fine.
possession has been handed over.
That's it.
He is not well land.
What to do? This appeal under section 19 of the Contempt of Courts Act 1971 has been filed against an order dated 20th of August 2023, passed by learned single judge. Next.
Not well, at least she is 72 years old.
Or what to do?
She has left.
The order of the court binds everyone. What to do? They should have thought before vacating the premises, before this thing, she should have thought of the consequences. What can be done? See, Mr. If we take a lenient view, every other litigant will be encouraged to violate the law. Yes. Next.
Lordship, kindly.
Huh? Yes.
I am seeking some time.
Time. Why?
Senior counsel is sick. I'll post next week.
Who has to argue the matter? What's your name, Mr. So and so, Learned Counsel? What's your name? Shiv Kumar, Learned Counsel, submits that the matter is to be argued by whom?
Success. Shailesh Success.
Shailesh Saxena, Senior Counsel. Designated Senior Counsel.
Advocate. Senior advocate.
Senior. Is he your senior?
He is not designated. Senior advocate.
Are they? Learned Counsel.
Senior land counsel.
He doesn't. Has he been, Mr. Please help us.
Senior member of the bar.
No, we are not concerned senior or junior member. The fact remains that you are not an arguing counsel, you are not prepared. That is what is important.
Shailesh Saxena, sir.
Is he a senior advocate designated by this court under section 16? Then how are you telling us? Mr. Shailendra Saxena, Learned Counsel, who is unwell, list after 3 weeks. Yes. Yes, Mr.
Amendment to the rules notified by
You had right, yes. Heard on the question of admission. Petition is admitted for hearing. Issue notice. Yes.
May I please ask?
Yes.
I'm very sorry, my lord. Earlier I filed a writ petition before this honorable court, and this honorable court disposed of the writ petition directing the petitioner to approach the appellate authority under section 20.
Where is that?
I have preferred the appeal, my lord.
Ah.
Wide SR number.
So what happened, Mr.?
My lord, the appellate authority's tenure is over by 5/8/2023.
Huh?
My lord. The appellate authority's tenure is over, my lord. No appellate authority is functioning now.
So Mr. Who appears for PCB? So you are this thing, right? Contributing in your own way to the litigation, right? You feel that there should be more cases in the High Court. Don't take any action. Why your officer should not be placed under suspension? Tell us. Why should you not place the person concerned under suspension who sat over the representation and compelling the petitioners to come to this court? Why? You have given us this thing, right?
It's not the case that
No, they have given representations with withdrawal of consent for establishment. So what action have you taken? Have you rejected it that it is not maintainable? Whatever.
that's appellate authority is not appellate authority is there, but no member is functioning.
So we are asking you about what action have you taken on the representations?
I'll get instructions, Mulad, in this.
No, Mr. Next time, if you don't tell us that the representation has been decided, we will be compelled to this thing direct this thing to place the officers under suspension. I mean, this is despite the time limit furnished to this court by some other council.
First time,
Some other council has fixed a time limit for taking action on the representation. Despite that, it is not being taken. We will have to do something drastic so that to drive home the point, right? The pollution control board is not existing there to create briefs to you. So you stand up and advance notice and don't say anything.
what is existing?
No, you have to explain, Mr. File an affidavit.
Yes, Mulad.
Who will file an affidavit?
I'll get instructions, Mulad.
No, who will file an affidavit? We are asking you to file.
The cancellation of CF, that they are requesting to cancel
The
the
Commissioner of State Pollution Control Board, Regional Office 1, Rangareddy District, shall file
Construction is going on, my lord. That's
It's all subject to result of the writ petition. Issue notice, you say, issue notice to, notice on behalf of PCB is accepted, who is directed to file an affidavit. You file an affidavit, why he has not taken action? Yes,
Member secretary, my lord.
member secretary of Telangana Pollution Control Board shall file an affidavit. Correct? Yes, yes.
This present writ petition is filed by challenging the notice affixed in petitioner's.
This is under section 14, right? Huh?
Actually,
Then you have remedy under section 17.
the response.
DRT. We will not entertain this petition, Mr. T. When the order under section 14 has been passed?
Actually,
10th of July 23.
guarantor was,
Date.
this is the guarantor, my lordship, in this matter.
Date of notice.
Meanwhile,
Order under, you are trying to challenge the order under section 14 of the SURFACE Act, is it correct?
no, my lordship, I'm challenging the orders passed against the deceased person. I am the legal heir of the deceased person.
So you can challenge it in an appeal, not necessary that writ petition. Satyavati Tandon. In this writ petition, the petitioner has assailed the validity of the order passed under section 14. An appeal, Mr. It's an appealable order. All contentions can be urged. Yes.
Allotment order. Yesterday, lots of pays to grant status quo order. 26/9/2022 order. Question the allotment. Yesterday, lots of pays to grant status quo orders.
Yesterday.
Yesterday, my lord, one matter. 25/875 of 2023.
25/875
of 2023, of 2023, my lord.
Learned counsel for the petitioner sub. Yes, Mr. Rao.
PG medical admission matter.
So they are how they are converting this thing.
Now, circular has been issued that they'll conduct third round also for the in-service candidates.
So-
That's what I was told, madam.
So that relief is granted to you.
Yes, madam.
Right.
Your Lordship may.
Ah.
The third round will be announced sometime next week or within 10 days.
Yes.
Lordship may have this matter after 10 days and
Mr. Tirumala Rao, learned counsel for the petitioner, submits that
if he is permitted, my lord.
that third phase of counseling is scheduled to be held, shall be notified within a period of 1 week.
May mostly within 1 week.
Period of 1 week. He therefore submits that the writ petition be taken up after a week.
First week of October will be.
He
First or
therefore
second.
submits that the writ petition be taken up in the first week of October. Yes.
May I please. At the second time, filing this public interest litigation.
So, like, who are the persons who have 6 to
Yes, Milord. These are the persons who got selected on the bogus certificate.
where from have you learned this? A source of information.
Source of information, Milord,
Which paragraph of the petition? Which 20?
But in fact, that was not filed. I made a complaint that knowing information that they are not handicapped at all. But the director conducted the inquiry and those certificates are bogus. The certificates which were filed and obtained the employment as teachers are proved to be bogus.
Okay.
And the inquiry conducted by the collector. Lordship will find that the inquiry report of the collector, page 93 onwards. HIGHCOURT.
Third, on the question of admission notice.
Milord, the matter pertain to illegal constructions by respondent number 12 and 13, Milord. In agency area, particularly, secondly, in a Srinagar colony, Gram Panchayat. There were many notices issued by the Gram Panchayat authorities and also applications submitted by the petitioner and other tribal person, everyone. But being ruling elite people.
Third, on the question of notice. Admit notice. Yes. So that's given by me. Which ones? Because that has come from the owner. We can explain. For the reasons assigned in the communication dated 17/8/2023 addressed to Registrar General of this court. Time for decision of IA is extended for a period of 2 weeks from it's disposed to.
Some article page number, it's a short pass over, senior counsel is engaged.
So,
So I have some difficulty, my lord.
so when should we?
Maybe Monday, subject
Monday?
lordship convenience.
Monday is 25th September. I Learned Counsel for the appellant praised for a short accommodation list on 25th September 23.
That's fine. Interim order needs to be extended.
Interim order.
I beg to appear. The writ
Yes.
appeal is filed against orders dated 27/9/2022 minutes passed by the last single grade.
Yes.
The facts of the matter, Millards, is that the state government, Millards, had come up with a agriculture loan waiver scheme, Millards, for poor farmers. But GORT number 69, Millards, which is in page number 23. Millards, as per the said scheme, Millards, the bankers along with the district collector, Millards, were required to identify poor farmers, Millards, and a waiver of maximum amount of rupees 1 lakh, Millards, was allowed in the said scheme, Millards. Wherein, Millards, the state government will repay the loan to the bank, Millards, and the bank can waive off, Millards, the said loan to the farmer. In this particular, there are certain guidelines prescribed, Millards, for granting this particular scheme, Millards. Wherein, Millards, the maximum amount is rupees 1 lakh, Millards, which is in page number 24, para number 3. The list may read, Millards. The list of farmers in annexure A and B should be compared by the bank.
Hey, what, Mr. 1,47,835, you must have spent more amount in litigation, right?
Millards. Now,
What is this, Mr.? You should have some sort of a litigation policy that amounts below 5 lakhs we will not want. You must have, what is this widow and poor farmer widow you are fighting against?
No, Millards. I have no objection in passing on the benefit, Millards. So my only difficulty, Millards, is that anchor is not the person who has formulated the scheme. It is the order has to be against the state government. The difficulty is the learned single judge, Millards, due to oversight, Millards, may have passed an order directing me to pay 1
So you
lakh.
should have put it to the notice of the learned single judge, right?
Insofar as my loan account is concerned, Millards, it has already been closed by the Millards. I am not disputing it. I'm also not disputing, Millards, that he is not entitled for the scheme. if the state, my only difficulty, my lords, is that
You could have filed, no? This is a clear-cut case of review. Learned counsel, we will permit you to file a review. Learned counsel.
And they have to recover from the government. They have to claim from the government. It is not the petitioners who have to claim from the government. Because as per the GORT, assess and they have to claim from the government. If the now order is modified to recover from the government, well, again, the
Not modified. We have. Mr.
Liberty.
Please tell him what order has been passed. Yes.
much of it.
May, Your Lordship. So this is a matter regarding land acquisition aspect, Your Lordship. The writ petition was partly allowed. The only grievance this petitioners approached this honorable court by writ appeal is the factual aspect and legal aspect regarding gazette notification of extension of preliminary notification was not properly considered by learned single judge. Is our grievance, my lordship. One aspect, single aspect regarding factual aspect of gazette publication of extension notification of preliminary notification. Lordship may say
You had urged that ground.
yes, my lordship. I had
Then file review.
filed memo, my lordship. I replied.
Review. File review. If you had urged the ground not considered, then 82 Supreme Court 149 review.
So, your lordship, the honorable judge has given finding.
Then you don't say not considered.
Challenge, no, not properly considered. I'm sorry.
That's a different.
That's what I said.
Yes.
Your lordship, only one aspect, my lordship. Then single judge legal said, your lordship knows 11-1 notification expires if declaration is not issued within 1 year period.
Yes.
Lordship, my contention is the gazette publication of declaration extension notification was issued after 1 year period. Learned single judge held that gazette can be issued any time after 1 year. Only the collector has to pass proceedings within 1 year of extension. Gazette can be issued any time. This is contrary to the law laid down by Supreme Court. Is my contention is one aspect. Regarding factual aspect, I pleaded before this before the honorable judge that they have backdated the publication as seen your lordship and seen the other issue, other case. Backdated. I made
This thing. Paragraph of the petition backdated.
yes, may
Start arguing something which is not your case.
no, same case.
If you want to this thing antedate and all that, show us where you are and here is the finding.
Your lordship, I will take up my memo dated 4/8/2023.
No, not for memo. Read petition.
Yes, my lordship. In memo, my lordship, I filed reply affidavit because as your lordship knows, reply affidavit I omitted. It was omitted from filing reply affidavit, which is part of the record of writ petition. Lordship may kindly say.
You are the petitioner, right?
Yes, my lordship.
So where is the question of reply affidavit?
During the course of arguments where they filed counter saying they are issuing
You filed a reply.
I replied. My submission.
Not in the original petition, right? You take this ground in reply affidavit.
In the also, my lordship.
Where is that?
Yes. Lordship may kindly take page 30 is my
Page
from 30 starts my writ petition, my lordship.
30.
Page 36, my lordship. Oh, sorry, para 6. Para 6, page 36 of
36.
Yes, my lordship.
Para 6.
6.
Yes.
I respectfully submitted to the given to understand the said declaration is invalid. The grounds that it was issued based on a lapsed level 1 notification without disposing our objections as per law, without following procedures so and so. I thought it was lapsed is my contention, my lordship. Further,
Yes.
in para 6, my lordship. Given to assert the said declaration is invalid on the grounds that it was issued based on a lapsed level 1 notification without disposing our objections as per the law, without following procedures. Now, this honorable court granted stay in 2019, my lordship, based on written submissions. Your lordship may kindly see. Interim order was granted. Page 78, my lordship. Sorry. I'm sorry, my lordship. Interim order is not. Interim order was granted, my lordship, at page
What is the point you are trying to make, Mr.?
The thing is, my lordship, they admitted
No, the notification under section 19(1).
has lapsed. It's not issued within 1 year. They issued extension.
The notification 11(1) issued when?
Your lordship.
Date.
21. I'm sorry.
21st May 2018.
Yes, your lordship.
And what is this thing?
21/5/2018 is the 11/1 notification date, my lordship.
Yes. So what is para 8?
And declaration, my lordship, 17/9/2019. Declaration date 17/9/2019, my lordship. So my contention is it has lapsed on 21/5/2019. It has lapsed. Now, the extension proceedings were issued, and they have not submitted gazette before. Only during final hearing in February 2023, they passed on the gazette notification to the late judge. They are not filed even in the counter affidavit, the gazette notification. 4 years.
There is a finding that this thing notification under section 19(7) was published on this thing 21st May.
Page 12 order
2019.
Yes, my lordship. Page 12 order starts, my lordship. The relevant portion is it, my lordship.
May 2019 before expiry of 1 year.
No. September 2019, my lordship. They issue.
Para 9. Para 9.
Yes, para 9 of judgment, your lordship.
Of course, because you have to essentially meet the reasonings. This is not an independent proceeding. You have to say how a learned single judge has committed and manifest.
Yes, my lordship.
Committed a manifest error.
Yes, my lordship. May I read the grounds, my lordship?
Mr. Paragraph 9, the finding is that the notification under 19(7) has been issued on 21st May 2019.
No, my lordship. That is the extension notification, my lordship. May I read, my lordship, para 9? May I read, my lordship?
That's what we are talking about.
Yes, my lordship. That is, I'll read it.
Mr. Array, please understand. 21st May 2018 notification 11(1) issued.
Yes, sir.
Now comes the finding in paragraph 9 that it was issued within 1 year on 21st May 2019.
That is the proceeding, not the gazette publication. Collector's proceeding, but the law requires that it has to be notified in the gazette, and the gazette date should be reckoned as the date of notification. Your lordship, further read, the gazette is only on 22/5/2019. Learned judge himself admitted that. No doubt, the said proceedings through which the extension of time was granted was published in Gazette 280 of 19 only on 22/5/2019. The power conferred on the second provisional sector to extend the period of 12 months prescribed is required to be exercised within a period of 12 months. Application to notify such extension, now the same on the website of the is concerned, the same not necessarily be within a period of 12 months. This is the legal finding we are challenging, my lordship. Because it is against the law laid down by Honorable Supreme Court. Once prescribed section ends on that, it would be suffice.
All right. Heard learned counsel for the appellant.
I filed Supreme Court order, my lordship.
Learned counsel for the
involuntary.
Nothing. We will hear him.
What's the
And
place?
as nothing will happen overnight.
What's the place? Milord.
I'm according to the respondents.
The branding of council corporation, Milord. Madam,
Huh?
next week, Milord, senior council is not feeling well, Milord.
Huh?
Senior council is not feeling well, Milord. Madam, I've taken
No, there is nothing like you are the senior counsel in this case. Against an order dated 14/2.
Yes.
The interim order was passed on 24/2/2020.
Yes, Milord.
And the conditional order passed by the DRT was that the bank may go ahead with the auction but shall not confirm the same subject to
So some settlement.
deposit of 20% of the amount in 2 installments.
Yes.
Right?
Some settlement.
No,
also,
nothing.
not further
No
like that,
judgment. Yes. So this order has been passed under section 17, applicable under section 18 of the Act. Go and file an appeal. We will make the order operate till you file an appeal. Within a period of 4 weeks, no senior counsel is required. This is a law laid down by 3-judge bench Satyavati Tandon. You know, day in and day out, we are passing these orders. It may be a good case for you on merits, but we can't entertain it here.
Sure.
Give madam that, Satyavati Tandon. In this petition, with consent of the parties, the matter is heard finally in this petition under, in this writ petition, the petitioner has assailed the validity of the order pending IAs are disposed. Yes.
Make legal.
Ah,
This is a public interest.
so this is to be admitted, it will be heard, right? Meetings are complete?
Yes.
All right, petition is,
Only one thing I wanted to submit.
yes.
But Section 40 of the HMDA Act specifically provides that the funds of the HMDA, that is Hyderabad Municipal Development Authority, it belongs to it and it should go into the fund of the Hyderabad Municipal Development Authority. They have issued one GO, but by which out of the 7,800 crores that they are receiving, 6,800 crores they are diverting to the government directly, contrary to the statutory provision. And only to that extent. But if the respondent number 2 may be directed not to transfer funds to respondent number 1 as being directly contrary to the statutes, but only that, I'm asking for the time being today. But while there are many other things, that need to be
What respond number 2 is directing?
Transferring money is about 6,000 odd crores to respondent number 1, contrary to section 40 of the Hyderabad Metropolitan Development Act.
Where is it? Section
Yes,
40.
Section 40, I'll just. GO 68. By way of a GO, the government is directed, contrary to the statute in my respectful submission, in which case not permissible. The GO is at page 84, I'll show that. But before that, section 40 of the HMDA Act. That is a statutory body created under the HMDA Act 2008.
Yes, metropolitan
Yes.
development.
39 deals with creation of the fund. Metropolitan Development Fund. In its application, the Metropolitan Development Authority shall manage and operate the Metropolitan Development Fund, which shall be credited, Lodges may see C, all monies received by Metropolitan Development Authority from disposal of lands, buildings, or other properties, movable and immovable. Then Lord F, all monies earned from remunerative projects and schemes by way of rent or otherwise and disposal of its assets. Then Lord H, sum of money received by way of user charges. Then I, my lord, any other sum of money received by the Metropolitan Development Authority from any other sources for performing its functions. And my lord, 2 deals with how the fund will be applied. But that is to develop infrastructure, my lord, in the Hyderabad Metropolitan Development Area. But directly contrary to this, Lodges may see, my lord, paragraph, page 84, 83 of the counter affidavit filed by them. They have respondent number 1 discloses, my lord, a GO number 63 dated 27/4/2023. My lord, page 83 of the counter affidavit of respondent number 1.
Hmm.
My lord, this is the amount being received for, my lord, giving away toll rights for 30 years on an outer ring road. Toll being given.
Page 80.
83. man. The GO starts at 83. The relevant portion is at 84.
Yes.
It starts at 83. GO 63 of dated 27/4/2023. Lodges may see para 7. The government, after careful examination of the matter, has agreed above and hereby issue the following orders. My lord, this is a toll being given away for 30 years on the road, but we have challenged that separately, my lord. That's a different aspect, but this part specifically, 7, the revised quote of so and so is accepted, 7,380 crores is accepted. Letter of acceptance accordingly may be issued. Then, my lord, it's written as 6, it should be Roman 3 actually. From the total concession amount of 7,380 crores, loan amount of 1,500 crores as availed by HMDA as against TOT, transfer of toll, amount receivable shall be retained by HMDA along with 2% administrative charges, and remaining amount shall be credited to the government treasury. But directly contrary, my lord, to the statute. And my honorable courts have held that a statutory body cannot be treated, while a state might have general overall control under the statute, my lord, it cannot be said that directly contrary to the statutory provisions, my lord, they'll divert the funds. And the funds, my lord, specifically is for the purpose of Metropolitan Development Fund to develop infrastructure. It cannot be used, my lord, for the purpose of expenditure outside the purpose, my lord, under the Act. And this GO is, my lord, directly contrary to the Act. But they let them not transfer this fund is what I'm seeking. My lord,
May I submit, my lords? In fact, issue raised, my lord, has been well answered in the counter. My lords, it's the instrumentality of the state. HMDA is not alien. My lords, in the event, my lord, if my friend succeeds, whatever amount is to be really entitled by HMDA, my lord, that will be always available. My lords, in the counter, elaborately, the issue has been answered. The matter required, my lords, an hearing. Subject to lordship's convenience, any day, my lords, your lordship.
What to say with regard to this clause being contrary to section 40?
My lords, the counter, para 31, it has been stated. Para 35, page 35 of this
35.
counter. Further, it is also submitted, para 30.
Yes.
Para 31, my lord, at page 35 of this material index of the count. Further, it is also submitted that the government that because the concession fees to be collected by HMDA, the revenue generated from monetization of ORR shall as such vest in HMDA is an argument that is wholly unsustainable in law or even otherwise. Toll revenue vests in the state. HMDA, HCSL were acting as a nodal agency on behalf of the state, in whom the right to collect toll was vested by the state. The money received its government revenue. The portion belonging to HMDA is the 2% administrative charges that shall be retained by the HMDA as administrative charges in accordance with the directions of the government. It is submitted here that the reference to section 40 of the HMDA Act may be applicable and not to the entire sum received as concession fee. It is humbly submitted that while the petition is relying upon the provision of HMDA Act, it is conveniently disregarding other provisions which duly clarify the role played by the state government in the execution of the roles and responsibilities as delineated in the said act. It is a settled principle of law that a party cannot be permitted to approbate and reprobate at the same time. My lord, the issue raised is require a hearing, my lords. I will satisfy your lordship, my lord, as to the
Transfer will be subject to result of the petition, we will say so.
Yes, my lord.
Right, it will be subject to, in any case, they can't.
Yes, and the only thing, I'll leave it to your lordship, my lord, I'll just state it.
How much time will you take to argue this?
But at only this point I will take.
No. How to, supposing we have to fix a date.
Any date.
No, we are asking you how much time will you take?
Maximum of 45 minutes to 1 hour.
Okay.
Maximum. I can conclude in 20 minutes also.
Give a synopsis, right?
Yes, but in fact,
the synopsis and this thing.
I thought if it is being taken up today, it is prepared.
We would like to hear the whole matters yesterday. So that's why yesterday we could not take up any matter from final hearing. We will take up this matter some other day. Could it be on 5th of October?
Yes.
5th of October.
My lords. Yes.
Yes, Mr. 5th of October.
Yes.
Learned counsel for the petitioner submits.
Of line may ask for one more, but let them not spend that money, my lord, in the meanwhile till 5th. That's it. I'll leave it.
Subject to your lordship and permission, I'm appearing for respondent number 4 and 5 in this matter. Lordship may kindly accommodate any week in that 9th week, my lord, if it's convenient. I have a personal inconvenience on 5th, my lord.
Oh.
Any day, my lord.
Yes.
9th or 10th.
My lord, maybe after vacations, my lord.
Vacation?
Yeah, that's right. After vacation.
That is a long day. Preparing for the private.
10th October, right? Fine.
In fact, we have to pay to
Deeply obliged.
10th October.
Yes, Milan, on the same,
10th October.
again on the same allegation was to be placed to dismiss the repetition by holding Milan that there is no material Milan that it was otherwise. We are concerned. 4 and 5 are concerned.
10th October.
Deeply obliged.
Huh? Everybody has filed counter. Everybody has filed counter.
Eighth respondent at 5.
All right. Petition is admitted for hearing. Interim order granted on earlier occasion shall operate during the pendency of this petition. This has already been fixed, Mr. Prabhakar, in the month of January 24. Why it has come? That too on a mention memo, we believe.
File an INT of 23.
3 of 23. No, but we have already fixed it in month of Jan.
Yes, sorry.
It's an IA 3 and 4. What happened is, for the inquiry,
I was here and I appeared. What we found is the entire proceedings are contrary to these rules. Your Lordship may kindly have a look at IA3.
What is IA3?
53. In WA 656 of 17.
So first we will go one by one. What is this 2 of 2017? 2 of 2017, give madam. 2 of 17.
Last
No, again it will come up, Mr. Then this IA. We have said January, again it will come up. So we want to decide it in itself. 1 or 2 of 2017, what is IA?
17 was disposed of on last date of hearing, but by mistake, the orders has come as IA3.
Huh? Which IA?
IA 2 of 17 was disposed of.
2 of 17. No, it is 3 of 17, it says.
In the order, it's last date as IA3.
2 of 17, madam.
693 of 17.
1 of 17, right? No, 2 of 17. What is the IA?
Application for being mentioned. Seeking liberty to take action against.
And, direction of CBI inquiry.
That is.
1 or 2 of 17. Have you filed?
Those ideas are disposed of with the direction, Lord, to conduct an inquiry and submit report to.
No, when? It is listed again.
WA 656 of 17 is disposed of.
656.
6 of 17. But that is the WA 693 of 17.
No. First we are taking up 656.
656 of 17.
Madam, this is
17.
656. 652 of 17 is a direction to seek CBI inquiry.
The inquiry that was, in fact, we are asked for the stay of the operation of the order. This Honorable Court directed disciplinary inquiry as directed by this Honorable Court and a submit report by end of this month. The inquiry is going on. With a disciplinary action initiated. Articles of charges have been.
No. So what is 2 of 17 CBI?
Filed after the charge sheet was filed.
2 of 17.
Yep.
Last time I submitted that this can await till January.
This, as far
Along with the
as his own request, January it can be. That's the main writ petition.
This can await. That's what I said. Submitted that. Because
Third on IA number 2 of 2017, learned senior counsel for the app.
of 17 can be disposed of together.
1 of 19. All right.
19 and number 3 of 23.
3 of
656 of 17.
2 of 19 is to receive document.
That can be
1 of 19. 2 of 19 is 1 of 19 you are saying can be considered.
the other application.
All right.
2 of 19 is to receive the document that can be ordered.
Receive document. What do you say? 2 of 19.
They are not part of the documents in the inspection unless I find a subsequent.
IA number 2 of 2019 and application.
Along with all these
That's not
applicants, along with the writ appeal, your
I
lordship,
don't
has since
present-
been-
I don't
let's see the main writ
I
appeal.
don't accept.
IA.
Yeah, that, not.
Acha, learned senior counsel for the appellant
Lorships
does
are
not
hearing-
press. Huh?
Lorships are hearing it, so I don't.
No, not hearing. We are deciding your IAs, Mr.
Saya, I am saying not press. DA for fixing date of.
No, we are passing orders on your IA only, not finally hearing today.
Understand.
Learned senior counsel for the appellant, they still don't want to press this IA? Learned senior counsel for the appellant seeks leave of this court to withdraw IA 1 of 23. Accordingly, same is dismissed as withdrawn. Then 2 of 23.
IA 1 of 23 is in.
Huh?
23 is in IA 693 of 70. This is an application.
3 of 20, IA 2 of 23, right?
That side.
Decided?
No,
When?
that can be decided after IA 3 of 23 is filed.
Achha. Then 4 of 23.
To receive documents.
4 of 23.
It's proposing it, third party affidavits may not, it's not necessary in this
All
proceeding
right.
at
So
all.
you want to file counter?
Yes,
How much time?
yesterday it was filed.
Ah.
Your lordship, may say 10 days.
Learned senior counsel for respondent press fund is granted 2 weeks time to enable him to file counter to IA 4 of 23. Then we have 3 IAs now. So
This honorable court, when I was constrained to file a writ petition before this honorable court, after giving notice to all the concerned and making them your nominee parties, including all the members of the. Yes,
You have been stated in possession, not
no,
yet.
I am out of possession.
Then what happened in the writ petition then?
This honorable court found that the collector has committed the mischief and disciplinary proceedings should be initiated against him. And not only against him, but against all the officers who are part of the NOC committee. Because they are subordinate officers that
They are conducting an inquiry.
Now they-
You say that it is not in accordance with rules, and according to you, it is being done to exonerate him.
One submission. Why I am saying that is, at that point of time, when there was a direction that he should be, disciplinary proceedings should be initiated against him, he was in the municipal administration department. The collector, the then collector. Thereafter, now today, he is the principal secretary to the revenue department, promoted to, he has got 2 promotions after this directions. Now in the normal course, it should have been placed under suspension. Secondly, who are the officers who are now deposing? The Tehsildar, the RDO of the revenue department. Come and make a deposition, and in the cross examination, all documents which are not part of the record are placed before him and they are marked through these revenue officers. This is the thing. Then when I went there, I said, please show me these documents. They say you are not entitled. You are only a witness. Whatever questions we put to you, you answer and then get out. I am the last witness. That is what I have said. Then the rules prescribe as to how the procedure, the inquiry has to be conducted.
No, but they are saying that they will not pass an order and place the inquiry report before us.
It's fine. If that's
That's what we said.
My lords, in fact, my lords,
I have no objection.
this is, my lord,
I can't have any objection.
the inquiry, my lords, is commenced and my lord, the report will be placed before your.
Initially, your grievance was, Mr. The inquiry was not being held.
Yes, my lord.
Once the inquiry is being held, now you say that it should be accepted.
Your lordship will see.
Mr. Prabhakar, when you first time you argued, your grievance was not doing anything.
Not
Now they are doing.
everything they have done in a week's time. What they do is, your lordship, can we imagine the Tehsildar deposing against the principal secretary of the same department?
Minutes.
So wherefrom we are not supposed to get witnesses from Russia in the departmental inquiry. What can we do? Mister, if you had any independent witnesses, you should have given the list to them. But Tehsildar is being subordinate. This person is my man, he should be examined. You should have given. What can we do?
My lords, in fact, my lords, the title dispute.
We don't.
Title dispute.
I'll answer. I'll answer. There is a query from the court. Let me answer. Not in on fitness. Not this man can't preside now in the revenue department. Not what is this?
The object of this, if it is co-warranted, then different thing. You file
Yes.
that he can't continue, we will consider.
This directed the report to be filed periodically. Now that is the report filed. Therefore,
Yeah, and Mr. Prabhakar, we appreciate your grievance, but like, I mean, what can at this stage we do? I mean, you see, you are saying that the subordinates are being, so wherefrom we should with the court bring witnesses against him?
I'm not saying no. Not all I'm saying is they can't now decide over the revenue department. He is the revenue department, the only department that he
But
can.
file an application, you are making oral submission, there is no prayer.
That
We
is
will
what
deal
I'm
with it.
Yes.
What I'm saying.
Which IA? So they are entitled to file reply.
I'm just because the Supreme Court directed me to give a speech. That's what I'm saying.
Yeah. List on 3rd of October for consideration of these IAs, everything. Yes. Yes.
I appear for the respondents.
Ah, yes.
I have to explain whether the urgency pending from 1982, the disputes.
Huh? 22 to 34. Ah,
It appears-
yes. Why this vacate stay petition? Who has filed?
I filed vacate petition, the urgency was pending from 19.
No, this is, Mr. But this is stays 26/6/2018 directing parties to maintain status quo and creation of third party right.
But I'm only saying that the urgency has been pending for quite some years. The Lordship may fix a date and hear the matter finally, whenever Lordship.
All right. Write down. Third on the question of admission appeals. Up.
We filed in my name. I did not make any application.
No,
That's
he has made a, he is, did you not hear? Please tell him
I
what
did
you
not.
tell the.
Today it's up.
No, you tell him what submission have you made.
It's a date per se. Minutes, I was not knowing that an application is made today. Minutes.
Tell him what order we have passed, Mr. This probably too much that we pass an order and tell them also. You tell him what order we have passed.
I don't. I'm only seeking
This
now.
what we have said. Tell him, Mr. Venkatesh, please tell what is. You tell him what order. He has interrupted us.
Minutes, my submission is one in this minutes. Earlier also they made an application for the series of appeals in this. Walkport earlier appointed a senior counsel. So minutes dates were fixed for him. That is the only difficulty we have. If the time is 6 minutes, they wanted to have a senior counsel from Delhi, then it was not listed at that point of time. So that difficulty, minutes were kindly also consider that we have some sufficient time for me also, Walkport also to make our arrangements.
Mr. Venkatesh, be ready. He is trying to frighten us by saying that I will get a counsel from Delhi. He did not say International Court of Justice to frighten us. Don't
that
This is, we are not concerned. We are concerned with the we are concerned with the council, not with location. He may come from Australia also. Doesn't matter. Doesn't matter. Why Delhi? Get him from Australia.
Minutes, I'll withdraw that. Minutes, I'll withdraw from that.
This is really, we don't accept this. I'm withdrawing this. Don't share the location. You are not what Mr. Venkatesh, you have failed in your duty to convince your friend. Please tell him what order has been passed and what stage.
Kindly appreciate my aspect.
You tell him.
My difficulty. I have heard that. I don't need Venkatesh for that. Lordship, kindly consider one aspect if I can impress upon this honorable.
Right. You argue Venkatesh step, Mr. He is opposing the prayer. Yes.
No, I'm not on that. Yes. I'm not on that.
You want an argument. Argue, Mr. Why do you want?
Minutes,
no, they are not agreeing to
apology. With an apology, Millard, your Lordship, kindly permit me half a second. Then I'll leave to Lordship. Leave it. I'll do that.
We were only
given a very wrong impression. I withdraw all that. I'm not making anything.
Don't frighten us that council is. We will show him his place.
I'm not able to tell that.
Yes, to say that. Tell what the history, geography. We are not concerned. He did not. The matter did not reach. For this, you cannot blame me. I was not there in when the case did not reach. What they did it relevant.
With an apology, I'm withdrawing all that.
Venkatesh, tell him.
With an apology, I'm withdrawing all that. Let it be as it is. It will be taken up 17 minutes. And I once again will
explain it to him that it is being taken up for finally.
Again, I will apologize, my lord, if I've given a very wrong impression. I didn't mean anything. I only was surprised that my application, I was surprised that I did not make it. But I leave it that, your lord.
You don't want it to be heard, right? You don't want this appeal to be heard.
No, I'll be willing at any point of time, your lord.
We have not vacated the stay. We have fixed the appeal for final hearing on 17th October. If you have any problem, challenge this order in
everything, Lord, which I gave any wrong impression. I apologize for that. I'm withdrawing all those minutes which gave a wrong impression. Your lordship kindly not take it.
Because it
Is
should
it
not
so?
reflect on the case, my lord. My wrongdoing may not affect. That is not fair, my lord. But I have seen this court, the court that will never reflect on the cases. In fact,
I don't know. The attempt is to, we will recuse them. List before a bench in which one of us write the name is not a member. Yes. Fine.
But I still want to apologize, my lord. I don't know what I made wrong, but.
No, you are saying that it will reflect on the case. That means, in fact, it's per se contempt, Mr. Telling a judge that it will reflect on the case when the judge has not done anything.
No.
And telling that it will reflect on the case. Mr. Was it fair on the?
I apologize on behalf of the entire parliament because I have seen you a lot. I never not do that. Well, it's my bad. Maybe I have not made a right submission. I will recuse my lord.
We have no interest in betraying here. It will come before the, sorry.
I'm saying
Sorry,
that
sorry, it will come before another bench.
absolutely my bad, my lord.
No, nothing.
Which I
No, that day, it will come before another bench. You should have, no, we don't want to hear the lawyers who do not have faith in this court. Why other cases to decide, we will decide it.
I stand Millard on my own. I withdraw after what I said and I've given a wrong impression. It's only my bad day. Bad woman on me, Millard. I don't know what happened. Suddenly, Millard, with this application, I may have said that. I am once again giving my apology. Unconditional, Millard. I did not mean, Millard. I have never done that in any court. And I would not plan to do any point of time. Millard, I never said so in any event. I will not said so.
Millard, may I request, Millard? Your Lordship may not say so, Millard. Your Lordship may hear this matter, Millard. Back to the bar, Millard.
Supposing, no,
My friend may be on the.
we don't know. What happens is,
I don't do all these things.
Mr. Venkatesh, see, I am not interested in deciding.
I know,
this
but
case. 1 minute. You, all of you have said whatever. See, we are not supposing, we don't know what is the subject matter because it has come up on vacating stay. So I don't even know what is the order passed by learned single judge, what are the grounds of challenge. Supposing if we hear the case and decide against him, I don't know. He will think that it has adversely reflected on the case. Why to have that impression?
I'm standing up to
I
say.
don't know.
I'm standing up to
We
stay.
don't know.
Again,
If it is allowed, he will be fine. He will think that, no, judge has not permitted to reflect on the case. Supposing if it is decided, he will feel that since I told the judge, even though he said no, but it is reflected against me in the judgment. Why to take this? There are other honorable judges who can hear. Fine.
Millard, your Lordship may kindly permit me half a second, Millard, if your Lordship permits.
Now the case is over, Mister. You should be happy. We are not hearing. This bench will not hear.
Half a second for myself, Millard.
Yes, please.
Because I have put up 30 years.
Yes.
I have not done anything or not a single suspicion which judges mistook.
Yes.
Today, I don't know why, my bad day. I must have not done that. I have not such so.
No.
Saying that.
See, Mister, I have also, like you, I have also put in 14 years of judgeship. Today, no counsel, Mr. Aditya Sundhi is there. Ask him, he is from, I have spent in his court for 4 years and 3 months. Nobody, no counsel has told me till today, 14 years of my judgeship that let it not reflect, even though I was much more harsh in Bangalore, he knows. I am very polite here. Despite that, if I get this comment, it is not for you. My satisfaction, I will refuse. Not because, see, Mister, I am not answerable to you. I am answerable to God. Right? To my conscience. I will not hear a case which will have a bearing in somebody's mind that it is reflected on.
Your Lordship, kindly, I have appreciated one aspect, Millard.
This is for me.
English is very English language. I must have used very wrong word.
No.
The guilt that I have said something which is not like by the.
No.
I never meant that.
No.
I am willing to file an affidavit to that. I never intended to do that.
I'll be here. I'm the Chief Justice of this court. You will have many other cases. Let us see whether your conduct reflects in other cases or not. Let's see that.
It's never done. Even
You yourself will find an answer to that, whether I have reflected in other cases, but I am not hearing this case for my satisfaction. Not for your in this.
I should not with this guilt, my lord, of making a wrong comment on the Chief Justice. I will never in my wildest imagine.
Then why did you say that let it not reflect on the case?
I did not.
You think that we are so small sitting here, but we are here to punish your client. I don't know. I don't know what is the subject matter, but still we are here to punish you.
I am saying it's a very wrong word, my lord. I am taking it back with an apology. Only apology. Only because, my lord,
What happens if it is decided against you?
well, nothing will happen if it is decided against me. Me or I've grown in this court to say that.
Thank you. Now let's move forward.
This guilt, my lord,
It's not the only case on the list. Others are waiting, please.
But,
You will appreciate.
this guilt of not having apology from the.
You have apologized. I have the right to ask another. You have apologized. I am not saying anything. Let us see whether in other cases when you appear, whether it reflects or not. Let's see. I will ask myself this question, whether when you appear in this case, whether it is reflected in other cases.
It will not, well, I know it will not. But it's
Thank you for giving me compliment which I did not get in 14 years. Every day is a new experience and we should learn perhaps. Thank you.
sometimes we make mistakes, human error.
Next case. Next.
Your lordship has not accepted that. That's what is worrying me.
No, not. It is accepted. It's over. When you will appear in another case, you will see that.
I don't have to wait
But
for
in
that.
this case, I will not hear. If it is decided against you, you will think that it has reflected.
It's not.
Nobody should have that sort of an apprehension. No person who comes to this is a temple of justice.
Yes.
Nobody should have that apprehension. You are having an apprehension that your behavior is reflecting on the, may reflect on the case, so you should not have that apprehension.
But I did not say, I did not mean, I was not meaning that. So it was only the subject is, it was showing 19, I got by half of the hour. So then I was only trying to tell the court that
We were only fixing a date. We asked you whether 17th October is fine. You should have said that it's not convenient. We would have fixed another date. We have not vacated the order granted him. He said that don't vacate the order and instead hear it finally. Despite that, he told you what is the order first.
I was not trying to listen to my anxiety to put across to the. That was
There is nothing, Mr. I don't want to prove myself to anyone, right? There's no question of I am not saying that you are saying an apology, we will not accept it. What? Will punish myself only by not accepting the apology. There's no question of accepting apology. It should be next case. Please. Thank you. We will hear you in some other case. Yes.
I'm going to do that.
Yes. We will hear you in some other case. Thank you.
I want to leave with an apology.
Yes,
Your lordship.
Yes. Accepted, Mr. Apology accepted. Yes.
It is only to say that we need some nights and need some time to adjust. That's what, and nothing else than that. Your lordship may kindly, I can only say that it's my endeavor to say that.
So which date you want then, Mr. Venkatesh now?
I am ready.
His choice. 17th is inauspicious for him, so you tell a date of your choice.
Sometime if I need, I only.
No, you are not required to do all this for getting a longer date, right?
No, I don't want now. Now I don't want. On that day we make submission, only thing difficulty would be more getting.
Well, your lordship, I written it, my lord.
For that, my lord, and we say the lordship.
I am appearing for Wakford, but presence may be recorded. I am
That's
ready.
No, so, but he is not ready on 17th.
Yes, sir.
So all this is only because we would have given any other date, Mr. Rao.
It is ready on 17th, my lordship, I
No,
written it.
not ready. He
This is ready.
wants some difficulty. Which date you tell, or whichever date you say, we will fix it.
Personally, I am not in position today, my lord, so I was not ready with this. I'll have to consult board officers. That's what But I'm not making any further submission. I'll leave to your lordship's kind in
No,
that.
no, we are asking about 17th.
No, any
We
your lordship.
will adjourn it to any other date also according to your choice.
No, but
We were only asking you the date whether 17th suits. We thought that this appeal is
No, but
pending since
I-
2018. It needs to be heard. Only we were wrong. Why should we are not, nor are we interested in properties, nor we are going to get it, even if we decided.
I want now leave to your lordship's kind indulgence. Any day.
Let it be 17th also, we will adjourn, Mr. 30th October. 30th October. Yes,
Lordship permission.
35. Yes.
I'm grateful.
Yes, yes.
Section 35, I'm representing my lord, K. Ravi Mahindra.
Yes.
Point number 7.
What happened? Have you filed counter?
They filed the counter, my lord. I reply also.
The respondent
Government also filed the counters.
37.
1 minute.
It
Yes.
belongs to single bench matter and they have transferred to this bench without without notice on
Transfer
me.
to which bench?
In the last occasion, we got the notice of the Ram Court about filing other two petitions. Your lordship asked whether you filed a vacancy petition. I have not filed. Then your lordship told to file a vacancy petition. We filed vacancy petition. The matter listed today, my lord.
Ah.
The
I am not ready, Lordship, any adjournment may be given. I am not ready, any adjournment may be given, Lordship.
Any adjournment?
May be given.
Why? You want an adjournment?
Yes, Lordship.
My simple question is, my lord, they are claiming
He's
property.
going for adjournment. This is a public interest litigation. There is an interim order. So therefore, it's a personal litigation, right? Not the public interest.
Your lordship notice, my lord.
Madam, Mr. What we feel is approach in a public interest litigation has altogether to be different. You should act as not an adversarial like his enemy, right?
Not like that, my lord.
So he is praying for adjournment on the ground that he is not ready. Still you want to oppose.
No, not
Or we will vacate the stay and then grant this thing.
your lordship next week, my lord.
3 weeks time may be granted, Lordship. And one another expedition is there, connected to this matter.
Which petition?
WP 34686 of 2022.
No, we don't know. You file an application in case you want it to be listed. It's before this bench.
No, Lordship, it is before single bench, subject to this matter only.
Then get it. We can't you make an application to register.
I will make application, Lordship.
When I filed an application in this case, my lord, to make a demarcation of the school lands as well as the properties of the seventh respondent.
Learned counsel for respondent number
7.
prays for adjournment to enable him to prepare the case. Next.
Item number 38.
Yes. 30.
I have paid.
Yes.
But I paid for the respondent.
Yes, Mr.
These are the synopsis, Lordship. Kind.
Oh. Yes.
But the Ministry of Defense, not is the appellant before Palace. The Retapil Block 5, the challenging judgments plot is number 10138 of 92, but dated 9/8/92. But wherein the initiate the proceedings for acquiring the land of not the layer of the page 30 is not prayer.
1 minute.
Page 16.
No, but in this case, we remember there is a this thing, right? Report by some this thing that you are in.
With all due respect, we are disputing not that report. Because our officers, they are present in the survey. There was a mark, more than 30 to 40 members are there. They are not permitted to participate in the survey.
Where is that survey report, madam?
And the survey numbers did not reflect, not tallying in the survey also. It's a malafide one, with all due respect.
No, what else? So have you filed anything to objecting to this survey report?
No.
You have to see, Mr. This, on of AC, we don't have any reason to disbelieve the survey report unless you dispute it.
I dispute not respectfully of this, I am disputing.
There's nothing,
Because-
right?
It's subject to what, Mas? 1965, the property has been acquired. 1981, we were include the subsequent land of some. From that day onwards, from 1981, we have been agitating. The entire the counter for single judges, we are not responsible. State government is responsible. They have acquired and handed over for DMI. But today, state government is not before an appeal before this court. Then, you also would notice this survey report was conducted pursuant to order dated 7/11/2005. As by this court, on 7/11/2005. So, this report has been filed on 20th March 2023 after so many years. Now, clearly they said there is an excess land. If there is excess land, please initiate the acquisition. That's what the learned single judge has said. Except that nothing else is there. They are not even saying state government restrictions.
Because the demarcation of survey number 39 on 1 and 40 of 1, not 42. Last may kindly see the counter, the counter before going to the survey. I'll demonstrate how I am on the instructions, I am submitting that.
You have to file some affidavit, something on this. Disputing this survey report, so long as it stands, we wonder what can we do.
I'll file,
Last may go to page 9 of the interim order. Everything is clear.
It's my appeal.
It's your appeal, but unfortunately, you're not able to say that.
No, your appeal.
All right. Yes. Don't lose your smile for anything, Mr. Praveen Kumar. It is so precious, right? Page.
Page 30, it's additional count.
Page
30,
30.
Yes, it's additional counter filed by the district collector administrative service. Here, the earlier counter, in addition to earlier counter.
This is Madam WP 656. I kept the IS 656. Yes.
That he has filed this counter there are two middle the present additional counter Lordship found middle. The present additional counter is being filed with a view to bring certain relevant and crucial aspect of the case to the notice of the Honorable Court to certain misstatements made by the provision previous LEO on the basis of mischievous report of a surveyor which has been discovered to be false subsequently, also to view to place subsequent development before the Honorable Court. Last kindly turn to next page. The land acquired survey number 39 18 acres 35 guntas and 40 acres 40 20 acres 17 guntas. The draft notification on 5/2/1964. The possession of the acquired land was taken from the fourth line. The possession of the acquired land was taken on 28/2/1964 and 1964, including the lands in survey number 39 and 40. Compensation was fully paid to the respective claimants as per the award. The beneficiary under the scheme of the acquisition, that is Union of India, has been in possession and enjoyment of the land acquired since last 36 years. No lands other than these acquired are in possession of the government.
there is no excess land as now alleged in malafide. Now, my lord, it may be here submitted that after acquiring the lands in question, there has been vast development in the area. The Union of India laid internal roads, constructing buildings for the office purposes and huge laboratories after providing safety zones, etc. They have also constructed hundreds of staff quarters. The entire extent of land acquired for the defense wing been encompassed by the compound wall on the sides, and security towers were provided around an entire site. The land in survey numbers 3940 was utilized for construction of staff quarters along with other lands in survey number. The entire extent of the land acquired by the defense wing is being used since the last 36 years. It is submitted that the acquisition of the land establishment DRDL and Himala in Kanchanbag area are rapid operations around defense laboratories.
Yes.
Now, next page, that's maybe the relevant not page number 8, not para 8.
Yes.
It may here be submitted that at the time of acquiring the lands, subdivision sketches were prepared in respect of individual survey numbers. The compound survey number 39 was subdivided into 39 by 1, which is situated beyond the compound wall, which is neither notified nor acquired, and the subdivision of 39 by 2 to the extent of 1835 guntas was land notified and acquired. Similarly, survey number 40 and subdivision into 40 by 1 and 40 by 2. Subdivision 40 by 2 to the extent of 20 by 1. Now, my lord, 39 by 1 is my lord 18.35 guntas. Subdivision 40 by 2 is 28.17 guntas. The survey, my lord, now, may kindly peruse the survey. The map, my lord, the enclosed along with the survey.
Yes.
Well, where the map may not enclose on the survey, that's kindly peruse. The map may not, along with the survey may not, survey. The recent survey may not conducted in March. The map may not. The defense land, the demarcation is not there, but 39 and 40. They show me that 49 by 1.
You file objections, Mr. Duja's report.
One more submission, but the memo may not have filed.
Yes, Mr. Venkatesh. We'll pick it up next week.
Because the issue is with the learned.
Yes.
Correct or not?
Now, this until they file objection, this.
I was dated 20th February 23,
Ah. Yes, Mr. Praveen, when will you file? 1 week.
I'll ask my kind individuals that 2 weeks time because it has to
I
be.
think this is an old matter, Mr. 2005. You should have, you have heard it.
That's all, that's only Milad. I'm openly Milad.
27 September. 27 September. Learned Senior Counsel for Respondent has pointed out. Needs to file their title deed. That's why Yes. Yes, ma'am. 39. Yes.
Petitions of the appellants. Petitions submitted, they had a layout. There was a small extent of about 459 square yards. 498 square yards was left as an open area. Now, under the rules as that it stood at that point of time, the AP Municipalities Layout Rules 1970. But I just bring some facts that may not be. What else?
Yes.
Not as per rule 3, the VP municipalities rules. As
Yes.
it then stood, but I may have
Municipalities rules.
18 municipalities, not correct.
Yes, yes. 1970. Andhra Pradesh Municipalities Layout Rules 1970.
Under 10, then I'll take your lordship. I have a small clarification to make to the bench. But under that rule, where the layout is less than 1 acre, 1 hectare, the municipal council is competent to make a resolution subject to the concurrence of TTCP, except this extent of land which is left over for a public purpose. Unmarked lot. That such a rule is there. In this case, there is a letter forwarded by the municipal council to the DTCP. DTCP neither accepted it nor rejected it. So it is subject to their DTCP rejected it. That is the rule. But then what was passing in my mind is now Telangana Municipalities Act 2019 has come. That is that.
Yes.
And so far as the provision relating to the what should kindly have a section 299 of this act.
Andhra, where is Andhra? The rules. Andhra
I'll pass
rules
on
1970.
I'll
Section.
299.
So. 290.
Telangana Municipalities Act. Because that was under the AP Act when the writ appeal was filed.
And this is repeal and saving.
Yes. On and from the commencement of this act, subsection 3, notwithstanding the repeal of the acts referred in subsection 1, the appointment, notification, order, scheme, form, notice, rule or bylaw license or permission granted under the Act shall, in so far it is not inconsistent with the provisions of this Act, shall continue in force and deemed to have been issued or granted under the provisions of this Act, unless it is lapsed or superseded by any appointment, notification, order, or scheme, form, notice, rule, or bylaw made or issued, and any license or permission granted under such provisions. Now, my lord, there is also Telangana Municipalities Development Land and Layout Rules 2019, framed under this Act. But that is not ever.
Regularization of layout.
No, that is not available in the textbooks, my lord, because they've got. I just pointed out, but just
So what, I mean, what the point we are trying to make?
that rules, my lord, there is no such rule.
Ah,
I can't. It's my duty to.
yes, thank you.
Under the Telangana Municipality Development Land Layout Rules. Lord, what we were proposing was, in fact, asked our clients.
No, but your application will be governed by AP rules only. I mean, how can the subsequent rules apply to your application, which was rejected? It will be governed by AP rules. So what is wrong with the order passed by Learned Single Judge? You tell us.
But we have
nothing.
We have an alternate land. We submit a representation that one consider. Same
That you can always do.
The same extent, unless such a liberty is given, but they may not. Small extent of 500 square yards, same extent, they are, that also belongs to us. That liberty can, they will only consider if it is permissible.
So use this thing, then we will, this thing, without adjudicating this thing. You, at the outset, this inter-court appeal has been filed. This inter-court appeal under clause 15 of latest patent has been filed against an order dated 27th June 2008. Yes, Mr. Sundi.
I beg to appear.
Oh, yes. Yes, Mr. And Mr. Advocate General, what is this about?
My lord, sir, this is the land is, my lord, subject to the Jagir law, my lord, sir. By virtue of the abolition of Jagir, the title of complete village of Sultanpalli, my lords, vested in the state. My lords, certain proceedings emanated, my lords. This is the third round of litigation, in fact, my lords. Now, whether the notice which was issued for my lords to conduct an inquiry as to whether the Board of Revenue passed its orders, my lords, regarding the entire subject property. And in fact, my lord, the entire land in that Sultanpalli village is Jagir. What was, my lords, on account of certain proceedings later, where the Jagirdar claims to have had patta lands. Whether he had the patta lands or not, my lord, is the crucial question that is involved. There is also a civil proceedings pending before the civil court. My lords, as far as the notice which was impugned, my lords, the state justifies the notice because what is to be done is to implement the earlier orders passed within the domain of the revenue authority. That can't be found fault with at all, my lord. There is nothing that can be determined by virtue of the notice which has been issued. Merely because, my lord, it is issued at a belated stage. There is nothing, my lord. Title will not be decided by the administration.
Give us some facts. What are
Maybe lordships, my lord, say, page synopsis, for your lordship's convenience. Is already. Please pardon one handwritten note.
What is the notice dated 21/6/2005?
That is at page 54 of the compilation, the green book, my lord, which we have compiled.
Yes.
E-book. Yes. Wait.
Yes.
My lord, the
please.
notice, sir. Your lordship.
All right, sir. Yes. Paper book you have.
Yes.
Yes.
In order to, my lord, page 54.
Give us some facts, Mr. What is this?
My lord, facts or my lord, the entire land, the subject land is Jagir land. Whether, my lord, what they say, the writ petitioner says, my lord, it is not Jagir land and it is a patta land of Jagirdar. My lord, sir, the subject to Sultanpalli village, the entire village is Jagir. And the Jagirdar was paid commutation amount of rupees 60,000. My lords, what flows from this Jagir abolition regulation is vesting of title with the state and the entitlement of Jagirdar. That is commutation amount as prescribed under the rule, under the regulation itself. Nothing else, my lords. The right is only commutation amount that has been paid. And once that is paid to the very Jagirdar, my lords, the claim that there was a private patta land, my lords, that is not accepting certain stray revenue entries. They have not placed any urgent evidence that it is the private land of the Jagirdar. so as to, my lords, to enable him to deal with the property as that of a rightful owner. When the entire land of Sultanpalli village, my lords, one of the argument that is advanced is the commutation do not refer to the survey numbers. My lord, when the entire village itself is Jagir, the question of a mention of any specific survey number may not arise. My lords, I'll just read the notice, my lord, what was sought to be done by the government, the joint collector Rangareddy district, page 54. In order to implementation of the orders passed by the then Board of Revenue, Hyderabad in file number so and so, appeals Hyderabad dated 20th July 1951, and the orders passed by the then Honorable Minister for Revenue, Government of Hyderabad in file number so and so dated 18/11/1952, read with under Rule 4 of rules regarding grant of Pattadari rights in non-Khalsa village, published in Gazette number 32 dated 19th 1356. Firstly, circular number 2, Revenue Department dated 18th October 49, and circular number 12, Jagir Administration dated 3/11/1949, in respect of the land bearing survey number so and so at measuring acres 307.35 guntas, new survey numbers so and so, at measuring acres 307.35 situated Sultanpalli village, Shamshabad Mandal. Therefore, the case is taken up for hearing under section 166B of the AP Telangana Area Land Revenue Act 1317 firstly, and section 9 of the AP Rights in Land and Patradar Passbooks Act 1971, and posted for hearing on 1/7/2005 at 3 p.m. before the Joint Collector, 1 Rangareddy District, at Office of Collector so and so. Therefore, you are required to be present before this court either in person or through an advocate on the said date and time, along with supporting documents in their favor, failing which the matter will be decided on the material available on record. My lords, this notice was impugned by the writ of prohibition. My lord, the earlier history, my lords, I will also take your lordships to the earlier history of this subject land. And the learned, my lords, may I invite your lordship's kind attention to page 57 of this compilation. There were 2 writs, my lords. Order in WP 11064 of 2005. There are 2 orders, my lord. At page 58, my lord, the relief sought by the very same petitioners. The petition under so and so, my lords, writ of mandamus or any other appropriate writ, and direct the respondent to act in accordance with law and forbear from interfering with the position and injury. This running page top, my lords, 85, my lords. I am sorry, my lords. Running page 85 on the top of it.
This order is 10th of May.
10th May.
So this is page
85.
Yeah.
I am sorry. This is to forbear from interference, my lord. The order passed, that is, the last para, my lords, will. Insofar as respondents 5 to 11 are concerned, no direction can be granted by this court against any alleged action of these respondents seeking to dispossess the petitioners, as the petitioners have an appropriate remedy against such private respondents before the jurisdictional civil court. Insofar as respondents 1 to 4 are concerned, these respondents being the state or state actions are obligated to so conduct themselves to be in accordance with the mandates of the rule of law of the Republic. On the aforesaid analysis, the writ petition is disposed of directing the respondents 1 to 4 not to take any steps to dispossess the petitioners. If the petitioners are in possession and enjoyment of the lands in survey number so and so Sultanpalli village, Shamshabad Mandal, Rangareddy district, except by following the due process of law. The petitioners are also at liberty to seek appropriate remedies for establishing their title and possession of the lands in question. My lord, sir, the very same land judge was pleased to pass the orders in the impute order in WP 14038, my lords, of 2005, page 89, my lords, this order. This order dated 5th of June 2009.
Yes.
My lords. My lords, sir, page 96, the stand of the government, my lords. Just 2 pages, my lord, that will. The second respondent.
This is some other writ petition, right?
No, my lord, this is the impugned, my lord, sir, in this writ. Yes.
Hmm.
My lords.
Yes.
The second respondent has filed a counter affidavit on behalf of the other official respondents as well, stating Sultanpalli village and is an ex-Jagir village of late Muhammad Kahir Ali Khan Amirul Mulk. Later, by succession, the Jagir devolved on Sayyid Shabuddin Hussaini, Sayyid Karra Haidar Hussaini, and Fakrunnisa Begum. The Vasul Baki register of the village sets out the name of the Jagir as Khatedar in respect of the lands covered by certain survey numbers mentioned in the Vasul Baki register. But in the remarks column, it is mentioned Khatedar is Jagirdar of the village, but actual cultivators are others. It is further noted that as per the new rules, Patta should be transferred in the name of cultivators. Circular number 12 dated 3/11/1949 clearly stipulates that no Jagirdar or Hissadar or his relation can enter his name as Patadar unless the land was personally cultivated by him, and that any such entry shall be carefully investigated, that any grant of patta for a land in contravention of Rule 4 of the rules regarding grant of pattadar rights in non-Khalsa village shall be cancelled, and record must show the name of the person who is in actual cultivation, contrary to the rules. However, the names of Jagirdar is continued in the revenue records as Patedar. Historically, the Jagirdar was a mere administrator for the purpose of collecting the revenues and to manage the day-to-day affairs. While the administration of the land revenue and its collection was not directly administered by the erstwhile government, was administered through intermediaries. The lands directly administered by the government were termed as Khalsa lands, whose lands administered through intermediaries were termed as non-Khalsa lands. The intermediaries included the Jagirdars and Deshmukh, who used to collect revenue from the area or village within his authority or jurisdiction, retain his commission and remit the balance to the credit of the government. The lands within the authority of a Jagirdar are Jagir lands and comprise patta lands of cultivators and communal lands. If there is personal cultivation by the Jagirdar, he could be registered as Patedar. Thus, Jagir lands do not per se and in the event belong either to the Jagirdar or to the state. By a notification dated 14/9/1949, the military governor, the Jagirs in Telangana area were abolished and the administration of Jagirs were transferred to the government of Hyderabad with effect from 28 September 1949. A provisional commutation award was passed by the Jagir administrator in proceedings dated 7/8/1952, provisionally determining the commutation sum in respect of Sultanpalli village at rupees 60,000. On 21st January 1957, The final commutation award was passed and the payment was received by the beneficiaries by 31st March 1965. The payment of commutation to the Jagirdars was intended to compensate for the loss of income and the abolition of Jagirs. The Jagir land thus stood converted into Raitwari settlement under the direct administration of the government. On the abolition of Jagirs, all communal lands vested absolutely in the state. The lands involved in the present writ petition are Kancha lands, grazing, that is grazing grass, and are thus vested in the government. This is evident from the fact that the Tehsildar had auctioned the lands for grass during 1950-51. Aggrieved by the auction, the Jagirdar filed an appeal before the additional collector claiming that the Kancha lands were recorded as patta in his name. However, the entries in the Vasul Baki clearly indicate that the pattadar is the Jagirdar of the village, but the actual cultivators are others. Under the rules, the patta should be transferred in the name of the cultivators. On the basis of such remark, in the Vasul Baki register, necessary corrections in the final entries in the revenue record should have been made, deleting of the names of Jagirdar from the pattadar column. This was, however, not done. The additional collector, ignoring the remarks recorded in Vasul Baki register erroneously by an order dated 12th August 1950 and the appeal filed by the Jagirdar, set aside the auction and held that Kancha lands were recorded as patta lands of Jagirdar. Agreed by the order of the additional collector, the then lessee, one Mr. Prabhu Lingam, filed an appeal before the Board of Revenue. The board, by the order dated 20th July 1951, observed that as the income of the entire Kancha lands were included in the 10 years income settlement for commuting a de novo inquiry should be held by the additional collector, and only lands under the personal cultivation of the Jagirdar should be allowed as patta in his name, and the patta of the other land should be cancelled as per the standing orders. Agreed, the Jagirdar preferred a revision before the government. The Honorable Minister for Revenue, by the order dated 18th November 1952, upheld the board's finding and dismissed the revision. Even the Jagirdar admitted this factual and legal position in his deposition before the Additional Revenue Divisional Officer, Land Reforms Tribunal, Hyderabad West, in CC number so and so, under the provisions of the Agricultural Land Sealing Act. The Jagirdar, however, clandestinely sold the property. I'm sorry, my lord, there's a disconnect of this paper. My lord, sir. The findings, my lord, these are the broad contentions, my lord. There were certain contempt petitions moved. That was also referred, my lord, in this order. I'll just take your lordship to the findings rendered by the land single judge from well, see, the earlier writ petitions were also referred from page 119 of this order, my lord, sir, from the para, my lords, the second para from the bottom, second para, my lords, internal page 37. Page 119. Internal page 37, my lord. From the bottom. In the light of the fact that there exist and operate several knotty, complex, interrelated and interactive factual and legal positions, which have to be analyzed as a prelude to determination of the nature and character of the land in several survey numbers in Sultanpalli village, including whether these lands are comprised within the Jagir or are the personal property of the Jagirdar. B. Whether the commutation award passed by the Jagir administrator on 7th August 1952 covered the lands in these survey numbers of the village as well. C. The fact that the order of the Board of Revenue dated 20th July 1951 does not pertain to and indicate any specific land by reference to any specific survey number. D. As also the potential defense by the petitioners as to having perfected their title to the lands by adverse possession, including through their predecessor in interest. The protected tenants are the Jagirdars, as the case may be. Such complex factual and legal positions cannot be determined in exercise of the powers under section 166B, and determination of rival and competing claims to title is patently beyond the province of provisions of the Land Revenue Act. This was not, my lords, contemplated by the joint collector to adjudicate. What is the power of revision under 166B is to correct the revenue entries, nothing else. The notice, my lords, are issued to the writ petitioners. Predominantly, my lords, the notice traces its authority and power to the board's decision and the decision in the appeal, wherein, my lords, from those two decisions, it will go to show and exhibit prima facie that the land, entire land at Sultanpalli village is Jagir land. The commutation award, which was also, my lord, available on record, would indicate that the Jagirdar was paid commutation and the two Hissadars were also paid their share. My lord, so when the first petitioner, since was found to be, since he was a member of parliament, my lord, there were complaints. My lord, sir, a house committee which was appointed, my lord, has extensively examined the entire land in Sultanpalli village. My lord, at page 217, the report of the house committee is available, my lords. This report referred to the entire history of the land, subject land. At 34, my lords, of this page, findings of chapter 3, my lords, it is divided into various chapters, my lords. The findings of the committee is in chapter 3 at page 34 of this report. At page 256 of this compilation, my lords. 256. The committee, 3.1 and 3.2, my lord. The committee felt the final decision of the Board of Revenue as upheld by the government, directing the said lands to be treated as government lands, ought to have been implemented by the concerned officers. It is a clear lapse on the part of those officers as they indulged in flagrant violation of the orders of the higher authorities. The committee has come to the conclusion that the land in survey number so and so, situated at Sultanpalli village, Shamshabad Mandal, Rangareddy district, belong to the government as per the records furnished to the committee and the evidence given by the officers before the committee, though there were some missing links in the record. My lords, at page 258, the internal page 42, This is the notification, my lord. There is no dispute with regard to that. The dispute is it is a private patta of the Jagirdar. My lord, page 43, next page 259, my lord said. This is a commutation award. In fact, my lord, I have filed also separately the documents. All compilation is available in this regards. In fact, my lords, an application was filed to receive certain material document that was considered by your lordships, my lord. This commutation award is at page 40, internal page 43 at material index 259, my lords.
Is here.
These are
Here also that is I think.
name of the Jagir, Sayyid Shah Shahabuddin Hussaini. Name of the Jagir, Sultan Palli. Taluk Shahabad. Sultan Palli, Taluk Shahabad, District, Hyderabad. Khata number 737. Verification slip number 372 dated 27th June 1952. In exercise of the powers conferred by Section 5 of the Hyderabad Jagir Commutation Regulation of 1359, firstly, the commutation sum in respect of the above Jagir is determined provisionally as rupees 60,000. My lord, so the AAB is, my lord, arriving at the formula. How 60,000 is arrived at is indicated. At the next page, my lord, sir, how it was paid to Jagirdar. Sayyid Shahabuddin Hussaini was paid 26,250. Sayyid Karar Haidar Hussaini, one of the Hissadars. Next, Fakhrun Nisa Begum. My lord, the next page at page 45, internal page 45, page 261, this material index, is a final award as regards to the commutation. My lords, prima facie, my lords, the entire property of Sultan Palli village, including this subject to survey numbers, the extent is, my lords, 307 and odd acres. As far as the 6 petitioners concerned, about 185 acres they have purchased in the year 1982. My lords, this purchase is per se void as no title.
How much they have purchased?
185 acres, my lord. This is narrated in this House Committee report at page
85 acres in 1980.
185, my lord. Total 185. If I am not mistaken, my lord, this is reported in this at page 238, my lords. At page 238 of this compilation. Mr. V. Tulsiram, the Member of Parliament, 83.04. His wife, my lord, 35 acre 28. The details are mentioned, my lord. Total 185.18 acres. We are concerned with Sultan Palli village, my lords. As far as Gagan part, we have nothing to do with that. My lords, the very learned single judge in WP number 1106 of 2005 has, my lord, this court observed to redress before the competent civil forum for establishing title as well as possession. And when the government is able to demonstrate that the entire property of Sultan Palli village is Jagir, my lords, the natural corollary is that the title is with the government of the entire survey numbers. And the so-called private patta, unless, my lord, it is established by the person claiming through the so-called pattadar, My lords, they can't simply invoke the jurisdiction of this honorable court under 226, challenging the notice, questioning the authority. What is to be, my lords, the authority will confine to the jurisdiction as conferred by law, that is under 166, be revisional power. My lords, as your lordship is fully aware as to how the properties of the governments are dealt with by the officers, and the mere delays in enforcement of the right for the public causes, they can't be said to be, my lords, at a belated stage, and the law relied upon by the other side, my lords, it in fact carves out in what circumstances the delays can be attributed towards the government in the matter of, my lords, these immovable properties of the state. Honorable Justice, my lords, 2010-5 SCC. Para 19. This one.
Page.
My lord, sir, 203. You must be aware of this answer. Para 19, my lord, sir. These delays can't be just like, my lord, sir, canvassed against the government. Para 19. Suits for declarations of title against the government, though similar to suits for declaration of title against private individuals, differ significantly in some aspects. The first difference is in regard to the presumption available in favor of the government. All lands which are not the property of any person or which are not vested in a local authority belong to the government. All unoccupied lands are the property of the government unless any person can establish his right or title to any such land. This presumption available to the government is not available to any person or individual. The second difference is in regard to the period for which title and or possession has to be established by a person suing for declaration of title. Establishing title possession for a period exceeding 12 years may be adequate to establish title in a declaratory suit against any individual. On the other hand, title possession for a period exceeding 30 years will have to be established to succeed in a declaratory suit for title against the government. This follows from Article 112 of the Limitation Act 1963, which prescribes a longer period of 30 years as limitation in regard to suits by the government as against the period of 12 years for suits by private individuals. The reason is obvious. Government properties are spread over the entire state, and it is not always possible for the government to protect or safeguard its properties from encroachments. Many a time, its own officers who are expected to protect its properties and maintain proper records, either due to negligence or collusion, create entries and records to help private parties to lay claim of ownership or possession against the government. Any loss of government property is ultimately the loss to the community. Courts owe a duty to be vigilant to ensure that public property is not converted into a private property by unscrupulous elements. My lords, most of the thirst of the petitioner is that you invoked your jurisdiction at a belated stage, and the case law which is cited, my lord, absolutely has no application in the given facts of the case. Therefore, my lords, if at all the person seeking for adjudication of the rights must, my lords, has to approach the competent civil forum. In fact, my lords, your lordship refers to the constitution by judgment of the Honorable Supreme Court, even referred to in your lordship's recent judgments. My lords, government can't be put to, my lords, an action against such a person who has no valid title prima facie. My respectful submission, my lords, merely because the commutation proceedings or the Board of Revenue order do not refer to a particular survey number of Sultanpalli village. My lord, the facts probabilizes and proves that the entire Sultanpalli village is a Jagir, and merely because it do not refer to a particular survey number. My lord, it does not mean that the Jagirdar held a private land. Nothing has been, my lords, established beyond any, my lords, appeal of doubt that yes, Mr. So and so was the Jagirdar, held the Patta lands. My lords, the Lund trial judge committed a blatant irregularity in the matter of, my lords, not appreciating the stand of the government, and even before, my lords, a notice is impured. Even before what is going to be decided, it can't be assumed that we are going to decide the title. What was sought to be corrected is, my lords, Pattadar Passbook Act was relied upon, and 166B, that is a revisional power of the government, was referred to, which is, my lords, they are referable to the correction of erroneous entries. That's it. That does not amount to, my lords, we cannot assume that we are going to decide, the authority is going to decide such title or other dispute. This is my respectful submission, my lords. Your lordship may kindly consider. In fact, my lord, we have filed a written submissions also about, in fact, about a year ago, we have argued the matter.
Where?
Reserved once. It was reserved, my lords. Your lordship may kindly consider the case law and also, my lord, the written submissions which I have placed.
Submissions, madam. Where?
Written arguments.
Written submissions. One thing we can assure you is that this will be decided.
Yeah, my lords, we are familiar with.
Yes.
We are grateful for that, my lords. Yes. My lords, I have not referred to the earlier proceedings because they may not have. They also filed. I would have mentioned.
His written submissions.
I'll give it. This is on 26th July. Otherwise, I'll file it.
26 July 2022.
Wait, am I permitted to file again, my lords?
Yes, yes. Yeah, please give.
Yes, yes. Just sign it.
Yes, Mr.
Wait, please. Let's please come to the notice that was impugned before the learned single judge, which is at page 54. This was a writ of prohibitio, my lords, and therefore it is for me to show that this notice ex facie, my lords, is without jurisdiction, which I will, my lords, seek to do on 3 grounds. Firstly, my lords, this notice is issued in order to implement the orders passed by the then Board of Revenue, Hyderabad, dated 27/1951. Now, my lords, implementation of the orders of the Board of Revenue does not arise within the context of Section 166B of the AP Land Revenue Act. 166B, my lords, is a power of revision which can only be exercised, my lords, where some order passed by a subordinate authority under the Land Revenue Act. And admittedly, my lords, from a reading of this notice, it is not targeted to any order of a subordinate authority, but is in implementation of the orders of the Board of Revenue. Secondly, my lords, this question as to whether the Board of Revenue proceedings at all apply to the petitioner's lands has already been conclusively decided, my lords, in the previous round of litigation to which the state was a party. Right, my lords, the judgment dated 24/3/2000 of the learned single judge, which is at page 60 of the appeal papers, and confirmed in writ appeal by order dated 11/11/2002. And before I take your lordships to those orders which, in my very respectful submission, conclusively clinched the issue, my third submission on this notice is, my lords, from a bare reading. The notice is issued, my lords, 75 years after the, I'm sorry, my arithmetic is a little weak. It is issued, my lords, 54 years after the Board of Revenue order dated 27/1951. And therefore, my lords, it is beyond inordinate. And your lordships have consistently held that any administrative action must be within a reasonable period of time, even delay in some cases of 4 or 5 years. For example, under the Karnataka PTCL Act, has been treated to have been, my lords, fatal to the case of the state. That's, my lords, the rest of my submission. Now, kindly, my lords, please come to the earlier order of the learned single judge, which is at page 60 in the writ appeal paper book, my lords. Order dated 24/3/2000. Yes. Notes what was impugned in that writ was a memo of 1993 issued by the state seeking to treat these very lands as Jagir lands, which is my esteemed friend's case, my lords, before your lordships today. Please see, my lords, how that memo was quashed by this order. Kindly come to page 65, my lords. The second unnumbered paragraph, my lords. The question that arises for consideration is whether the memo issued by the government is competent and within its jurisdiction. That the petitioners had purchased certain extent of lands from the Jagirdars and also from other persons who were conferred with ownership rights under Section 38E of the AP Tenancy and Agricultural Lands Act. The entire episode arose out of an observation made by this court in WP so-and-so of 1986. In the said writ petition, the petitioners sought for directions to the government to implement the directions of the Board of Revenue dated 27/1951. It appears that one Prabhulingam filed an appeal before the Board of Revenue against the Jagirdar Syed Shahabuddin Hussain regarding the auction of the gross of Sultanpalli village. Mr. Prabhulingam was unsuccessful before the Tehsildar and additional collector. In what connection the Board of Revenue, it should be in that connection, observed that the Kancha was not the private property of the Jagirdar, but it is that of the Jagir, and the auction proceedings of this Kancha was being credited to the Jagir. What was decided in the appeal was that the land which was concerned in that appeal was not under cultivation, but the gross was being auctioned. It is worthwhile to mention, kindly mark this, lords, that there was no reference to any survey numbers. The Board of Revenue further observed that only those lands which are under actual cultivation of the Jagirdars should be allowed to continue with as patta, and the patta of other lands should be cancelled. There is no detail as to what are the lands on which the Jagirdars were holding patta and what are the lands which are forming part of the Jagir. There was no reference whatsoever about that. But however, it appears that some persons filed WP so-and-so seeking a mandamus directing the government to give effect to the order of the Board of Revenue dated 27/51 and for consequential directions. The said writ petition was disposed of by an order dated 17/3/89 with observations which are extracted below. These observations, my lords, refer to the House Committee report that my esteemed friend had referred. But thereafter, my lords, please see, from this judgment, it is to be noted that the committee constituted by the Legislative Assembly, Lordships, it is to be noted that the committee constituted by the Legislative Assembly felt that the government ought to have implemented the directions of the Board of Revenue and that land in survey number so-and-so belonged to the government. Aggrieved by the proceedings the House Committee, the petitioners filed WP so-and-so. Since the Assembly itself was dissolved, the writ petition was withdrawn with a liberty to agitate the same if warranted. However, the government issued a memo dated 21/6/93, which was impugned in this writ, my lords, tracing out the aforesaid history and directing the collector to adjudicate on the following issues: whether the Jagirdar is entitled to Rayatwari Patta with reference to the land as per the provisions of the Jagir Abolition Regulation, whether the Rayata have acquired occupancy right in respect of the said lands. It is conceded that the regulations came into force from 15/8/49. Under the AP Abolition of Jagirs Regulation, all the Jagirs stood vested in the Jagir administrator by virtue of Section 5 of the regulations from the appointed date. The Jagirdar shall make over the management of the Jagir to the Jagir administrator. The Jagir administrator was appointed under Section 3 of the Act and the Jagir so vested shall be under the control of the administrator, and it shall be included in the Diwani until it is included in the districts constituted under the AP Land Revenue Act. It shall be administered by the Jagirdar. Under Jagir administrator, I'm sorry. Under section 18, the personal rights of the Jagirdar are excluded. Section 18 reads as follows: personal property and liability is not affected. Nothing in this regulation shall affect the personal property of the Jagirdar or Hissedar or any property other than the Jagir held by a Jagirdar on behalf of the Hissedars, or any liability of a Jagirdar or Hissedar in respect of any loan taken from the government. Now kindly mark this. Under regulation 20 of the regulations, any party aggrieved by the Jagir administrator under the regulation may appeal to the government or such other authority. Under section 21, no civil or criminal proceedings shall be initiated against the Jagir administrator except with the consent of the government. This part is crucial, my lords. Under subsection 2, that is of 21, claims relating to Jagir or any share of income thereof, whether arising under section 145 CRPC and civil suits still pending between the parties, it is established that they are the private properties of the Jagirdars. Even in the report submitted by the Revenue Divisional Officer, dated so and so, as per the records after incorporation of Jagirdar, it was found that Syed Shahabuddin Hussein's name was appearing as the Pattedar in respect of survey number so and so. In 1982, Jagirdars and the protected tenant holders became owners, sold certain lands to the petitioners under certain registered sale deeds, and the necessary mutation was also effected, and the same was implemented in Jama Bandi 1982-83. Therefore, from the sequence of events, it appears that the entire proceedings were emanated on the basis of the observations made by this court in WP so and so, wherein some petitioners sought for implementation of the orders of the Board of Revenue dated 27/1951. As can be seen from the order of the Board of Revenue, there was no mention about the survey numbers, and it was only an observation made by the learned member of the Board of Revenue. He did not specifically state that the land situated in survey number so and so formed part of the Jagir village. I just pause here for a moment, my lords. This finding that the Board of Revenue report was not specific as to the survey numbers, and therefore there could have been non-Jagir lands in respect of which the Jagirdar was a Pattedar, is final and binding. We have purchased the lands plots from the Jagirdar in respect of properties that are standing in Patta in his name. Now, my lords, if I may read further, he did not specifically state that the land so and so formed part of the Jagir village. In any event, the power of the government to direct the collector to adjudicate the matter under the provisions of the Jagir Abolition Act is the question to be decided. As already stated, any claims relating to Jagir lands or any share in the income arising under the regulation or otherwise subject to the regulation are required to be decided by an appropriate civil court. This is under regulation 21(2), my lords. It is clear that there must be a claim relating to the Jagir arising under the regulation. And in the instant case, nobody is claiming Jagir share in the income. Admittedly, Syed Shahabuddin Hussain was Jagirdar owning some private lands, a part of which also went to Sheetal Singh and others who were protected tenants, who also sold some of the land to the petitioners. The lands forming part of the Jagir vested with the Jagir administrator, and thus they merged with the Diwani. Under these circumstances, two important questions would arise: whether the government has got power to initiate such an action as referred in the memo, and whether it would be open to the government to conduct inquiry after a lapse of nearly 50 years. May I continue after lunch?
Yes.
Great. relevant portion of the earlier order, my lords, in the writ petition. Para 3. The following points have to be adjudicated upon. Whether the Jagirdar is entitled to Rayatwari Patta with reference to and as per the provisions of the Jagir Abolition Regulation, whether the rights have acquired occupancy rights in respect of the lands in their possession. The collector, Rangareddy district, is therefore requested, this is, my lords, the extract from the memo of 93 that was impugned. The collector, Rangareddy district, is therefore requested to make a due inquiry in the matter and decide the above point after giving notice to all parties concerned, keeping in view the fact that the relevant date to be considered in this inquiry is the date of coming into force of the AP Abolition of Jagir Regulation Act 1358 firstly. We kindly mark this, my lords. The government is proceeding as if the lands in question were Jagir lands and vested in the government, which is ex facie misconceived. Further, there is no provision for adjudicating the respective rights under the regulation. In such an event, it has to be adjudicated only in a civil court as contained in section 21 of the regulation. It is further to be noted that under the provisions of the regulation, there is no such provisions as to conduct omnibus inquiry, and that too by the collector. To exercise certain functions under the statute, the authority should be vested with such a power. If no such power is traceable, it would be an exercise in futility, and such an action of the authorities will be declared ultra vires, the powers being without jurisdiction. Accordingly, there is no power in the regulation authorizing the government to direct the collector to adjudicate the matter as to whether Jagirdars were entitled for Rayatwari Patta. In the absence of such power, it would not be appropriate for the government to initiate proceedings under the regulation. An action which is impermissible under the statute cannot be allowed to be initiated in the guise of administrative power, which cannot be achieved directly, cannot be allowed to be achieved indirectly. Whether Jagirdars are entitled for Rayatwari Patta or whether riots have acquired occupancy rights cannot be adjudicated under the provisions of the regulation, and it is only a civil suit which has to be filed in and the matter to be decided by the appropriate civil court. Admittedly, civil disputes are pending, that is not between the alleged riots and the petitioners. Further, there is no provision in the regulation to suo motu revise or review the orders passed under the regulation. Even if such a statutory power is vested, it is held by a catena of decisions of the apex court that such power should be exercised within a reasonable period. This was said in respect of the 1993 memo, my lords. The same thing has been sought to be done once over in 2005. The matters were settled 4 decades ago. Therefore, by virtue of the present proceedings, it cannot be allowed to unsettle at this distance of time. Moreover, the revenue authorities recognize the sale deeds executed by the Jagirdar and also protected tenant holder who acquired ownership rights, and names of the petitioners were mutated and their names were also entered in the revenue records. The learned government pleader lastly submits that there is no mention about the lands held by the petitioners and therefore the petitioners have no cause of action. I am unable to accept this contention. The entire events right from the time of the filing of the petition and also the report of the committee, that is the House Committee, my lords, constituted by the Legislative Assembly, would indicate that the proceedings relate to the lands held by Jagirdars, which were in turn sold to the petitioners. Under these circumstances, I have to necessarily hold that the impugned memo is incompetent, without jurisdiction, and arbitrary. Accordingly, the writ was allowed. This was taken in appeal, my lords, by the government of Andhra Pradesh. And your lordships get the order of the division bench on the next page, that is 74, dated 11/11/2002. Please come to page 86, my lords. Having heard the learned counsel for the parties, it needs to be emphasized that if the petition scheduled lands are the very same lands covered by the decision of the Board of Revenue, it is trite. The petitioners cannot be permitted to re-agitate their claim that the subject lands are Patta lands and are not Jagir lands because the order of the Board of Revenue, as upheld by the government in the revision, was allowed to become final. Perhaps, realizing this position, the learned government pleader for the revenue, as well as Shri So-and-so, would strenuously contend that though there is no specific reference to survey number so-and-so in the order of the Board of Revenue, as a matter of fact, the same lands were subject matter of the proceedings before the board. Shri So-and-so would point out, by the time the Board of Revenue decided the appeal, survey settlement was not completed, and therefore those lands were not given survey numbers. Therefore, it becomes necessary for us in the first instance to resolve the question whether the lands covered by the order of the Board of Revenue are the same petition scheduled lands or not. Having heard the learned counsel for the parties, perusing the pleadings as well as the documents placed before us, we do not find any evidence to satisfy ourselves that the lands which were subject matter of appeal before the Board of Revenue and the lands which are the subject matter of the present proceedings are one and the same. The question whether they are one and the same, it is tried, is a pure question of fact, unless it is shown that a competent court of law or an adjudicatory statutory authority or quasi-judicial forum has recorded a finding on this factual question. It is not appropriate for this court, in exercise of its judicial review power under Article 226, to take up such resolution of disputed facts. Such a question, we are of the considered opinion, cannot be resolved conclusively and finally only on the basis of affidavits and counter affidavits. It requires tendering witnesses for examination and cross-examination. The petitioners in the writ affidavit filed in support of the WP in unmistakable terms have stated that the petitioners in this case are not concerned with either the other patta lands of Jagirdar or the Jagir lands as such for the purpose of the present WP. Further, the petitioners have contended thus: all the petitioners before purchasing the lands have verified with the revenue records and found that the land proposed to be purchased by them were patta lands of their vendors. Only after satisfying this, that their vendors have got full right of sale of the lands under law, the petitioners have purchased the lands from them for a valuable consideration. In context of the above specific pleading and in the absence of any satisfactory material placed by the state and its authorities or the pleaded respondents to show that the subject land is the same in both the proceedings, it is not safe for the court to assume that they are one and the same. Then, my lords, importantly, secondly, we also find considerable force in the contention of the writ petitioners that the state government acted ultra vires the regulation and without jurisdiction in passing the impugned proceedings, declaring that the subject lands are Jagir lands and they stood vested in the state government after the abolition of the Jagirs, and then directing the collector to determine the two issues set out by it in para 3 of the impugned proceedings. It needs to be emphasized that a statutory authority or an administrative authority should function within the parameters of authority granted to it by law. It is true that the executive authority of the state is coextensive with the legislative authority of the concerned state. Abolition of Jagir and taking over the management and administration of Jagir in favor of the government is a field fully occupied by the regulation. So any action, my lords, that the state has to take has to necessarily be under the Jagir regulations. It is well settled that if a field is occupied by the statute, it is not permissible for the executive government to meddle with the statutory provisions or do anything contrary to the statutory provision. Lords, I'll skip this portion to save your lordship's precious time and take my lords over the page to page 90, my lords. In fact, the last line at page 89, thus it could be seen that in a case where steps envisaged under subsection 1 of section 5 have been taken against a person, and that person who is considered to be a Jagirdar by the government comes before the Jagir administrator and contends that the land in respect of which the government has issued the notification is not a Jagir, but a private patta land of the Jagirdar, the Jagir administrator may be required to decide such incidental issue in order to effectuate the provision of the regulation. Be that as it may, the learned government leader as well as Mr. So-and-so were not in a position to refer to any of the provisions of the regulations or the rules framed thereunder to show that the government has the power to decide the question whether a land is Jagir or land in case of dispute. It is well settled that when the lawmaker designates an authority and confers certain statutory power to do a certain thing, that authority can alone exercise that power and not any other authority, whether superior or inferior. And if any external authority exercises the power vested in a statutory authority, the action would be condemned as ultra vires. Therefore, it is not permissible for the state to determine the rights of the parties. Realizing the difficulty to sustain the impugned action of the government, the learned government leader as well as Mr. So-and-so would maintain that the impugned action is not an action taken under the regulation, but it is an administrative action taken in exercise of the executive power of the state, and therefore no exception could be taken to the impugned action. This contention of the learned counsel should be noticed only to be rejected because it is well settled as stated above. It is not permissible for the executive government Some words are missing. What's to the middle? What's the word? To meddle. I'm grateful to my friend. Meddle with the statutory provisions in the purported exercise of the executive power. The executive government, by exercising executive power, can only supplement and it cannot supplant statutory provisions. It is not a case where the statute is silent and the executive government has stopped and stepped in and issued administrative instructions or guidelines to fill in the gap. So in conclusion, my lords, we cannot find any substantive or weighty reasons to interfere with the order of the learned single judge. However, we find some force in the grievance of the learned government pleader and Shri so and so that certain findings recorded and observations made by the learned single judge in the course of the order relating to the merits of the matter were unwarranted and unjustified. Accordingly, my lords, the writ appeal came to be dismissed with the observation that any factual findings that the learned single judge may have made on merits would not in any way influence or bind either the civil court or any statutory forum which may be called upon to adjudicate these issues. From Regulation 21(2), my lords, it is crystal clear that there is a non-obstante clause vesting the civil court with the exclusive jurisdiction to decide all questions, my lords, relating to the status of...
Where is that regulation?
Yes, lords. May I furnish to your lordships a copy? 2 copies. An extra copy, please. May I pass on my copy to you? May I? I'm so sorry. Please pardon the marking on that copy, my lords. So 21(2), your lordships will see, is a non-obstante clause vesting the civil court. The learned single judge has also, my lords, the honorable division bench concurrently held that under these regulations, the state government cannot decide the question of Jagir. If at all, it is for them to invoke this remedy. This judgment, my lords, is now final. Now, my lords, rather than approach the jurisdictional civil court under 21(2), before the issuance of the impugned notice in the given case, what, my lords, the state does is, it approaches the Jagir Commissioner under these regulations, which your lordships get in the brief list of dates that I have furnished to my lords at serial number 7. I'm sorry there is no date there, but this is sometime in the year 2004 that a petition is filed, my lords, before the Commissioner of Settlements under the Jagir regulation. This petition filed by the state also comes to be rejected. Kindly for a moment, my lords, see the order, page 55. Wait on this one. See the order dated 31/3/2005, my lords. Lordships. This is, my lords, the MRO Shamshabad has filed a petition requesting to conduct inquiry and declare the lands in survey numbers so and so as vested in the government. Lordships, please. He has stated that the competent authority to decide this issue is the Jagir administrator under section 24(1) of the Jagir abolition regulation. The MRO has contended that Shri Shahabuddin Hussain, Jagirdar, seemingly got his name entered in the revenue records as Pattedar of so and so, totaling 307 acres, 35 guntas, in the year 1950 after abolition of Jagirs. It is stated that after the abolition of the Jagirs, the then Tehsildar auctioned the Kancha lands in the year 1950-51 in the name of Shri Prabhulingam, and an appeal by the Jagirdar before the additional collector requesting to set aside the auction was dismissed. A second appeal filed before the Board of Revenue was also dismissed with the observation that the lands in question were already established as part of Jagir and were not the private property of the Jagirdar, by virtue of the fact that the Jagirdar had already included its income of Kancha in the income statement and received compensation. The petition filed by the Mandal Revenue Officer Shamsabad has been examined and it is found that it is frivolous and ill-prepared. Section 24(1) of the Hyderabad Abolition of Jagir regulations talks about the rule-making power of the government and does not confer any power on the Jagir administrator to decide such matters as contended by the Mandal Revenue Officer in his petition. Secondly, if the lands which the petition talks about is the same land as covered by the board's order mentioned in the petition, the matter has already been conclusively settled and there is nothing left for this authority to adjudicate. If the records are not in conformity with the board's orders, the MRO ought to take proper action to correct them rather than filing such frivolous petitions. So, my lords, this order also is final. And in the teeth of these orders, this very same officer, who is the Mandal Revenue Officer, now initiates the proceeding, my lords, as an appellant. In the impugned notice at the previous page, your lordships find it's a peculiar situation where this Mandal Revenue Officer is shown as the appellant in these ostensible 166B proceedings, which is the impugned notice. He is the appellant and he is going to a fellow joint collector revenue official to adjudicate this matter, which is not under the contemplation of the Jagir abolition regulations at all. The sole remedy available already held is under 21(2), and it is pursuant to this, my lords, that this impugned notice has come to be issued. My learned friend contended that this is in the nature of a revenue proceeding, but with respect, my lords, the very preamble to the notice makes it clear that it is for implementation of the Board of Revenue proceedings of 1951 and not a revenue proceeding. And therefore, indirectly, in this proceeding, what the state is seeking to do is to overreach, my lords, the orders passed by this Honorable Court, by the Jagir Commissioner, and now try and have the Board of Revenue report implemented, which has already been held, my lords, to be inconclusive as regards the lands of these petitioners. Now, my lords, my friend had referred to the award that has been passed, my lords, to say that that award has some bearing on the matter. That award also, your lordships will find, is issued pursuant to the 1951 Board of Revenue report. And therefore, once the board report itself has been doubted by this Honorable Court, the question of that award, my lords, having any binding nature would not arise. And that award is in fact not even the subject matter of the subject notice. And therefore, my lords, I can just leave it at that. Now, my lords, in this background, kindly permit me to refer to the order of the learned single judge, lords, which is impugned before your lordships. Page 1, my lords, at page 18 of the writ appeal papers. Tell me what is this page. Sorry, my lords, I think there is some difference in the papers. I'll go to 29. The reasoning, my lords, begins. Would my lords please see internal page 18? Internal page 18, my lords, of the order of the learned single judge. That is running page 24.
Yes.
Grateful, my lords. That is where the analysis begins. To save your lordship's time, my lords, I will go over the page. Read, my lords, as is apparent from the pleadings by the petitioner, the counter affidavit by the second respondent, the several earlier proceedings, including the judgment dated 24/3/2000 in WP so-and-so and the judgment dated 11/11/2002 in writ appeal so-and-so. The impugned notice proceeds on the assumption that the land in survey number so-and-so of Sultan Pali Shamsabad belong to the state in view of the order of the Board of Revenue, Hyderabad, dated 27/1951, and of the government by the Honorable Minister for Revenue, dated 18/11/1952. The impugned notice purports to be a revision initiated in exercise of the powers under Section 166B of the Land Revenue Act and Section 9 of the Pattedar Passbooks Act. As the statement of objects and reasons underlying the enactment of the Pattedar Passbook Act discloses, the enactment is intended to be a fresh legislation applicable throughout the state for preparation and maintenance of the record of rights, repealing the AP record of rights land regulation. Section 12 of this act states nothing in this act shall apply to the lands belonging to the state government or the central government. The learned Advocate General appearing for the official respondents has also conceded the legal position that the impugned notice is not traceable to the powers under any of the provisions of the Pattadar Passbooks Act. So that provision, my lords, goes out of the picture. In these circumstances, the impugned notice and any further proceedings thereunder by the joint collector are not and cannot be justified as emanating from any authority, power, or jurisdiction under the provisions of the Pattadar Passbooks Act. The underlying assumption in the impugned notice is that the lands in question claimed for contra as belonging to the petitioners on valid and bona fide purchase from the Jagirdars from out of their private patta lands and from others who were conferred occupancy rights belong to the state, having vested in it on the abolition of Jagirs under the regulation. Whether the above factual assumption by the state is on the basis of conclusions recorded in proceedings by a duly empowered authority, forum, or a court, and if so, whether jurisdiction is available under the provisions of Section 166B of the Land Revenue Act is the issue that calls for determination in this writ petition. Then, my lords, the order of the Honorable Division Bench is referred. I will skip that, my lords, and take my lords directly to para 5 of the judgment, which is at in page 28. Aggrieved by the above direction of the state government, the petitioners filed WP so and so. This writ petition was allowed by the judgment dated 24/3/2000, which your lordships have seen, and memo dated 21/6/93 was quashed. There against the state and other official respondents preferred WA 732 of 2000. This appeal was disposed of by the judgment dated 11/11/2002. The learned division bench, while directing that the factual findings recorded by the learned single judge on the merits of the matter would not in any way influence or bind either the civil court or any other statutory forum or authority, which may be called upon to decide the basic issue whether the subject lands constitute Jagir within the meaning of that term, as defined in clause 2F of the regulation. Observe that such issue must be resolved solely on the basis of evidence that may be led before such court, forum, or authority as the case may be. The learned division bench, however, sustained the judgment of the learned single judge as regards the quashing of the government's memo dated 21/6/93 as being patently incompetent and without jurisdiction. Then, my lords, the observations of the division bench are extracted. I will not repeat those and trouble your lordships now with para 6, which is at page 32. Almost 2 years after the judgment in WA 732 of 2000, the fourth respondent filed a petition before the Commissioner and Director of Settlement and the Jagir Administrator, Andhra Pradesh, Hyderabad on 3/11/2004. The fourth respondent sought a declaration that the land in survey number so and so had vested in the government and the respondents, writ petitioners herein, have no right, title, or interest in the land. The Jagir Administrator, by the order dated 31/3/2005, which I read to your lordships, dismissed the fourth respondent's petition, holding that the petition by R4 is frivolous and ill-prepared, that Section 24 of the regulation, under which the petition was claimed to have been filed, deals with the rule-making powers of the government and confers no power on the Jagir Administrator to decide such issues, and that if lands referred to in the fourth respondent's petition are the same as covered by the order of the Board of Revenue dated 27/51, since the matter is already conclusively settled, there is nothing to adjudicate. It was also observed that if the records are not in conformity with the orders of the Board of Revenue, the fourth respondent ought to take proper action to correct them rather than filing such a frivolous petition. Apprehending dispossession of the respondents from the lands, the petitioners filed WP so and so. This writ petition was disposed of at the admission stage by the order dated 10/5/2005, directing R1 to 4 not to dispossess the petitioners that are in, if they are in possession and enjoyment of the lands. Thereafter, the impugned memo dated 21/6/2005 was issued. Now, my lords, the learned single judge refers to the writ appeal judgment from the point. The judgment in WA 732 on an analysis of the facts on record and contentions advanced clearly concludes that there was no evidence that the lands, the ownership and possession of which is claimed by the petitioners, are the same as those which were the subject matter of the proceedings before the Board of Revenue by the order of the board dated 27/51. The Jagir Administrator, while dismissing the fourth respondent's petition by the order dated 31/3/2005, recorded a complementary observation that if the lands claimed by the
Oh,
petitioners
this
are.
other part is not here in
Oh, I'm
our
so
copy.
sorry. Well, it's my friend's appeal, my lords.
A half page is missing, right? Recorded a complimentary. Thereafter, what?
Then, my lords.
Same in our copy. Give page 27.
See. I'm told it's at 118 of the compilation. Which is the internal page that I was reading. Now, what will be
1-1.
8 plots is my instruction. No, before that. So, here also it is blank. Where is it put? Give your copy. It seems it's not a clear copy in that compilation also.
No, here also.
There are extra copies.
Ah.
Give your paperwork. So, do you have an extra copy? The approved see. In the papers itself. Lordships have a clear copy normal.
No. This here also in paper book also this is blank.
Maybe pass on a copy.
Ah, yes.
Yeah. So
Please.
we'll make it good soon after. This. Put all the tax reading. Which one we got? 15, 50 got. No, so I'm going to put it back now. Also, I have a clear copy. May I give your lordships my copy? So,
Arey, Mr. Advocate General, you have a copy? No.
My lord, sir. Page 11.
Please pardon the
Oh, this
markings
is
on that.
99.
This thing. State gets away with filing the incomplete copy. No, our office also doesn't raise an objection.
My
All
lord.
right. Please. Yes.
Otherwise, with the writ papers, my lord, the order can be read from writ appeal papers.
Oh, but
Writ appeal papers.
administrator.
Please, notes. I was reading, beginning with the words, the judgment in W.
Yes.
Grateful.
You have a copy?
I'm reading from my friend's tab.
Okay. Yes.
I'm sorry, my copy is marked. Please,
All right.
please disregard that. The judgment in WA number 732 of 2000 on an analysis of the facts on record and contentions advanced clearly concluded that there was no evidence that the lands, the ownership and possession of which is claimed by the petitioners are the same as those which were the subject matter of the proceedings before the Board of Revenue, while the order of the board dated 27/1951. The Jagir administrator, while dismissing the fourth respondent's petition by the order dated 31/3/2005, recorded a complimentary observation that if the lands claimed by the petitioners are covered by the orders of the Board of the Revenue dated 27/51, there was nothing for the Jagir administrator to adjudicate. The counter affidavit on behalf of the official respondents filed by the second respondent in para 4 admits the possibility of lands within the authority or jurisdiction of a Jagirdar comprising also patta lands, cultivators, communal lands, as well as lands under the personal cultivation of the Jagirdar. This is at page 98 of the papers notes. I'll take your lordships to that. Section 18 of the regulation enacts that the provisions of this regulation would not affect the personal property of the Jagirdar, Hissedar, or any other property other than the Jagirdar on behalf of the Hissedar. Section 21(2) of this regulation enacts that all claims relating to a Jagir, whether arising under this regulation or otherwise, shall be subject to this regulation, but notwithstanding any existing law, be filed in and decided by the appropriate civil court. There is no provision in this regulation which consecrates power, authority, and jurisdiction in the Jagir administrator to determine whether a particular land is a personal property of the Jagirdar or otherwise. In view of the provisions of section 21(2) of the regulation, any dispute relating to a Jagir must be filed in and decided by the appropriate civil court. Even a dispute as to whether a particular property is the personal property of the Jagirdar or otherwise could be presented for determination before the civil court of jurisdiction, even if such a dispute does not classically fall within the contours of a claim referred to in section 21 of this regulation. This is so since the general legal presumption as to the existence of the jurisdiction of the civil court is not excluded by the provisions of the regulation. An integral aspect calling for determination in the writ petition is whether exercise of revisional power under section 166B of the Land Revenue Act is legitimate. The Land Revenue Act is an amending. This, my lords, deals with the background of the Land Revenue Act. I will skip that and take my lords to internal page 30. Lordships have it, my lords. It would be running page 36. Lordships have a clear. I'm so great.
It's not there, 36. You have?
Lords, kindly now come to.
In our copy, again, after 35 it is, my copy not there.
So, would page
yes,
30 be clear, my lord? Page 30 would be
yes.
grateful. In 30, the second unnumbered para, section 166B.
Yes.
Grateful. Section 166B of the Land Revenue Act confers power on the government or any revenue officer not lower in rank to a collector to call for the record of a case or proceeding from a subordinate department and inspect it in order to satisfy himself that the order or decision passed or the proceeding taken is regular, legal and proper, and to make a suitable order in that behalf. The proviso to subsection 1 of section 166B enjoins providing an opportunity to an affected right before passing any order affecting his rights. Subsection 2 of 166B, which is invoked, my lords, enables a revenue officer lower in rank to a collector or a settlement commissioner to call for the records of a case or proceeding from a subordinate department. There is no subordinate department here, for satisfying himself that the order or decision or other proceeding is regular, legal and proper, and if of opinion that such order, decision or proceeding should be modified or annulled, to put up the file with his opinion to the collector or the settlement commissioner as the case may be. Thereupon, the collector or the settlement commissioner may pass suitable orders under the provisions of subsection 1. There is nothing in the scheme of the Land Revenue Act in general or in section 166B thereof in particular, which expressly or by compelling implication inheres a revisional jurisdiction in the government, the collector, the settlement commissioner, or any other revenue officer to adjudicate and resolve rival claims by the state on one hand and a citizen on the other as to the character and ownership of the property. There are other circumstances which negate the exercise of the revisional jurisdiction in this case. Among the lands purchased by the petitioners in this several survey numbers in Sultanpalli village are lands claimed to have been purchased from the protected tenant on Sheetal Singh. The petitioners also assert that even the lands purchased by them from the Jagirdars are the personal lands of the erstwhile Jagirdars and not Jagir lands, and that they had verified these facts before they had purchased. It is also the clear assertion of the petitioners that the names of their vendors were recorded in the revenue records as patta land belonging to them, and after they purchased these lands, their names have been mutated in the revenue records, and they were also issued pattadar passbooks and title deeds for these lands. These assertions are not disputed in the light of the fact that they exist and operate several knotty, complex, interrelated and interactive factual and legal positions which have to be analyzed as a prelude to determination of the nature and character of the lands and survey numbers in Sultanpalli village, including whether these lands are comprised within the Jagir or are the personal property of the Jagirdar, whether the commutation award passed by the Jagir administrator covered the lands in these survey numbers, and the fact that the Board of Revenue dated 27/1951 does not pertain to and indicate any specific land by reference to any specific survey number, as also the potential defense by the petitioners as to have perfected their titles to lands by adverse possession, including through their predecessors in interest, the protected tenants or the Jagirdars as the case may be. Such complex and legal positions cannot be determined in exercise of the revisional power. That's the jurisdictional finding, my lords, and therefore the notice is found to be patently without jurisdiction. Then comes the element of delay, which is the concluding part of the impugned order. There is also the aspect of the exercise of revisional power being barred on account of inordinate delay. The regulation was issued by the military governor by virtue of the power conferred on him by a Farman of the Nizam dated 29/1948. This regulation came into force in 1949. More than 4 decades thereafter, by a government memo dated 21/6/93, an administrative inquiry was initiated on the assumption that the lands in Sultanpalli village had vested in the state under regulation. That was, my lord, set aside. Your lordships have seen that. Then the last line, my lords, of that para, this position is clear, and the state also concedes this position as presented by the learned AG, that assertion of the revisional power under the Pattadar Passbooks Act is wholly misconceived. Our analysis supra clearly indicates that revisional power under the Land Revenue Act is in the facts and circumstances not available. Alternatively, the revisional power under section 166B of the Land Revenue Act, even suo moto, and though no specific limitation is prescribed, is in the considered view of this court wholly unjustified and arbitrary. Then, my lords, the rest is on suo moto aspect, which I will, my lords, skip and read to your lordships the last para, internal page 33. In the aforesaid analysis, and in the light of several precedents referred to supra, the impugned memo dated 21/6/2005, issued on behalf of the state by the joint collector, is patently without jurisdiction, apart from being barred by inordinate and unexplained laches and delay. It cannot be sustained. Further inquiry pursuant to the impugned notice cannot be sustained either. The impugned memo is accordingly quashed, and the respondents are directed to forbear from proceeding further pursuant to the impugned memo. In the considered view of this court, the succession of ill-conceived administrative and quasi-judicial measures initiated for determination of the character of the lands in Sultanpalli village on an assumption of the state's title to them is on the basis of a misunderstanding that the state must identify and pursue remedies for executive maladministration, revenue mismanagement only within the administrative or statutory machinery, but should not pursue remedies before the judicial branch by way of seeking declaratory or other reliefs before a civil court of competent jurisdiction. No conceptual basis whatsoever for this fundamental misconception of the state is presented to this court, either in the pleadings or in the contentions advanced by the learned AG. In the considered view of this court, remedies available in the judicial branch, including before the civil court of competent jurisdiction, are available even to the state, and it is open to the state to pursue the appropriate remedies, such as for declaration of title or other appropriate reliefs, subject, of course, to the operative, substantive, and procedural law, including the law of limitation. Accordingly, my lords, the writ petition came to be allowed. And, my lords, therefore, in a writ of prohibitio, the learned single judge, my very respectful submission, has correctly found that the earlier judgment, my lords, of the learned single judge, confirmed in writ appeal, conclusively settles the question. And that apart, there is gross and inordinate delay now of over 50 years in initiating this action. And in any case, that action, my lords, is not contemplated under the Land Revenue Act, because it is in order to implement the report of the Board of Revenue, which has A, been held to be not conclusive, and B, in any case, is not, my lords, subject to the jurisdiction of the revenue authorities. It is, my lords, to be agitated under Regulation 21(2) of the regulations. I may just cite, my lords, before your lordships, two authorities. One is on, my lords, the scope of a prohibitio writ petition itself, only to reiterate the well-settled principle, my lords, that in order to keep authorities within the bounds of their jurisdiction, it's a
citation.
Yes.
Citation and paragraph.
Yeah, 1967.
67 Supreme Court.
1274, my lords.
1274 para.
Lords, para 5.
All right.
I need not read it to your lords.
Yes.
It's para 5.
Other one.
And, my lords, two judgments on the aspect of unreasonable delay in administrative action being fatal, which is, my lords, two well settled principle. One is 2018 12 SCC 527. Paras 12 and 13, my lords. Court officer, please pass it.
Yes.
That where, my lords, time in terms of limitation is not prescribed, it must be exercised within a reasonable period.
Yes.
That position. And interestingly, my lords, one judgment of a division bench of this honorable court, considering 166B.
We thought that you will cite Karnataka division bench dealing with reasonable time.
Your lordships.
All right.
I think I erred in not doing that.
All right. No, it's all right. Yes, lighter vein. Yes.
My lords, in the PTCL context,
Yes.
I've repeatedly. This was an interesting case where, my lords, 31 years delay in a proceeding under 166B was initiated at para 17.
Para 17.
Lords, 17.
Hmm.
It holds that the proceeding after a lapse of 31 years was grossly unreasonable and violative of fair play.
Yes.
And my lords, this judgment relied on by my learned friend, Hanumaya's case,
Yes.
is a pure case of limitation. That is, my lords, 2010 5 HCC. The question there was as regards the extended period of limitation given to the state under 112. The question as to whether administrative power, my lords, can be exercised after decades and decades was not the question at all. And therefore, my lords, my respectful submission is that the order of the learned single judge, my lords, is just and
All right.
so great. So great.
Yes, Mr. Advocate General. Yes, what do you say?
My lord, if anyone submits, I will submit at a stage. My lords, the earlier proceedings which my friend has read, my lords, I will read the complete portion of the order, my lords, passed in the earlier round of litigation by the learned single judge and also the division bench. They will have to be read in toto, my lords. May I read, my lords? Because since my friend has relied upon the earlier orders which have no bearing at all, as to the.
So, no,
sir,
what are your submissions? You tell us, then you can read.
Sir,
First,
my submissions
have no bearing.
My submissions are with regard to the contention that there has been delay. My lord, my respectful submission. From when the cause of action arose, my lord, the petitioners have purchased the property in the year 1982.
Yes, 82.
My lords, 82. On 12th of August 87, an issue was raised in the assembly about this purchase. My lords, committee was constituted and the report was submitted to the assembly in 88.
So, first is there is no delay in the fact.
My lords, in the matter of pursuing the rights, there is no delay. My lords, merely because a 50 proceeding is referred to or relied upon can never amount to say that the first time the state is invoking its rights under the 50 Board of Revenue order and the order passed in appeal. My lords, what my friend has argued with regard to the proceeding of
So, the first submission that in the facts of the case there is no delay, and the principle of delay cannot be invoked. Cannot be invoked by it if you are pursuing a right.
Yes, my lord.
From and second submission is what that previous adjudications do not apply.
Previous adjudication, my lords, findings rendered by the learned single judge.
No, previous round of litigation, you said no, it is irrelevant. Or
my lord, because the very findings rendered by this honorable court that the earlier round of litigation, my lord, even the writ appeal, there is a specific categorical finding that the learned single judge should not have, my lords, concluded the rights of the parties. He should have left open for the parties to decide or adjudicate. My lords, now who has to go before the civil court is the simple question. Who has to go before the civil court? And the inquiry post by invoking section 9 of the Pattadar Passbook Act and the Telangana Land Revenue Act under section 9 and 166B respectively are.
So, Mr. How do you explain the delay? Now, these are the two submissions, right?
My lords.
And now you can elaborate.
Yes,
this thing.
There is no delay at all in the matter of pursuing the rights by the government, as the petitioners started asserting right under the void sale transaction of 1982. My lords, in 86, certain issue has arisen in the assembly. 87, a committee was constituted. Report was submitted in 88. My lords, a memo was issued in 1993, which was impugned in the earlier round of litigation. My lords, the earlier proceedings ended in the final orders passed in writ appeal 732 on 11/11/2002. My lords, the Tahsildar approached the Commissioner and Director of Settlements and Jagir Administrator. My friend has referred to this proceeding. This is quite important document. The findings rendered in this order is not challenged by the petitioners. That goes, my lords, in favor of the government. At page 55 of this, my compilation, my lord. Just I will read the.
Which order? Order dated?
Order dated 31st March 2005. The argument that this is the request is rejected. That is not the purport of this order, my lords. 31st March 2005. Page 50, my lord, your lordship, material index, page 50.
Paper book, right?
Paper
book. Huh?
Yes. This is filed along with the writ appeal also, my lord, for the purpose of convenience.
But yes. Appeal paper book, it's page 55, right? Yes.
Yes. Yes. My lord, the bottom para, my lord, the petition filed by the Mandal Revenue Officer Shamshabad has been examined. It is found that it is frivolous and ill prepared. Section 24(1) of the Hyderabad Abolition of Jagir Regulations 1358 it talks about the rule making powers of the government and does not confer any power on Jagir administrator to decide such matters as contended by the Mandal Revenue Officer in his petition. Secondly, if the land which petition talks about is same land as covered by the board's order mentioned in this petition, the matter has already been conclusively settled and there is nothing left for this authority to adjudicate. If the records are not been in conformity with the board's order, the MRO ought to take proper action to correct them rather than filing such frivolous petitions. This order, in fact, my lords, there is nothing which suffered by the MRO. Rather, this Jagir administrator said if there is erroneous entries in the revenue record, take appropriate steps. That is what, my lord, the notice which is issued. What is section 9, my lords? Section 9 of Pattadar Passbook Act, this is, my lord, repealed, the new act has come, but section 9 is also a revisional power. There is no determination of, my lord, the right, title or other interest.
9 was given up by the learned AG before the learned single judge. 9
Yes.
was given up.
My lords, your lordship can always examine the legality or otherwise of a provision. Always, my lords. 9, what it says, merely because a law officer, my lords, gives up, still if it is, my lords, warranted by the court to examine, nothing prevents the court to examine. It's after all law. The Jagir administrator says if there is a wrong entries, you invoke the appropriate provision that has been done by the Tahsildar, the joint collector under.
So this is
My lord, section
2020 Act, right?
No, my lord, 71.
71.
71.
What is section 9? Please
My lord,
read.
section 9 says, my lords. This provision was invoked as then it was, my lords.
Yes.
Revision.
Revision.
The collector may either suo moto or an application made to him call for and examine the record of any recording authority, Mandal Revenue Officer or Revenue Divisional Officer under section 355A or 5B in respect of any record of rights prepared or maintained to satisfy himself as to the regularity, correctness, legality, or propriety of any decisions taken, orders passed, or proceedings made in respect thereof, and if it appears to the collector that any such decision, order, or proceeding should be modified, annulled, or reversed, or remitted for reconsideration, he may pass orders accordingly. Provided that no such order adversely affecting any person shall be passed under this section unless he had an opportunity of making a representation. My lords, section 3. The subject is section 3. What section 3 says? My lords, preparation and updating of record of rights in all lands. If someone bases, my lord, on a stray revenue entry title, my lords, if that is fraudulently made or incorrectly entered into the revenue records, well, under section 9, the authority has got power to get corrected those records. There is nothing illegal in this. Invoking such section 9 can't be said to be illegal. The Jagir administrator himself has observed that if Board of Revenue order is correct, there is nothing I need to do. Rather, you will have to invoke the appropriate provision of law to do the correct things. That's what it is done in this. As far as 166B is concerned, 166B of Telangana Land Revenue Act. My lord, sir, this is a suo motu power. Above all, my lord, there can't be any bona fide title that can be set up by the petitioners. Rather, my lords, by operation of law, Jagir abolition regulation itself, my lords, the title is complete title is vested with the state. (166) we may read, my lords, the power of Telangana Land Revenue Act. I'm sorry, my lord, we should have in fact provided all these copies.
Please read.
Subject to the provisions of the Telangana Board of Revenue Regulation 1358, firstly, the government or any revenue officer not lower in rank to a collector, the settlement commissioner of land records may call for the record of a case or proceedings from a subordinate department and inspect it in order to satisfy himself that the order or a decision passed or the proceedings taken is regular, legal, and proper, and may make suitable order in that behalf. My lords, if the revenue entries showing the name of a person as a patadar or other right holder, if such entry is erroneous or wrong, my lords, the revisional authority in the given facts and circumstances is justified to invoke the provisions of the Act. And my lords, the prima facie, the law infers a title in favor of the state. And the order passed in the Board of Regulation and the appeal, which confirms that the entire Sultanpalli village is Jagir land, is not challenged by the petitioners so far. In the absence of any challenge by them, my lords, they cannot impugn this proceeding, the notice, on the ground that you don't have an authority. What is that authority which I have exercised? Is look, there are erroneous entries. For correction of those erroneous entries, my lords, as directed by the Jagir administrator, in order to correct the revenue entries, my lords, the delays cannot be put against the state government. And above all, my lords, there was no delay at all. As such, the dispute started, or the claim started only under the purchase of sales of 1982, which surfaced when an issue raised in the assembly in 87. 88 report has been submitted. Pursuant to the my lord decision, 93 memo was issued, which was challenged. That was set aside by this honorable court. But my lords, in the division bench has said that as regards the memo, since you have no authority, but as regards the title adjudication, the party need to approach the court. And further remedies to be worked out by the state government. This is pursuant to that, my lords, the fresh proceedings have been initiated. And my lords, prima facie, the entire property of Sultanpalli village, including the survey numbers, are the property of the state government, and the inquiry proposed cannot be found fault with. And if at all, my lords, if they seek to adjudicate the title, when they assert the title as against me, as against the state, which is, my lord, by operation of law is the lawful owner of the property. My lords, if at all they want to work out the rights, my lord, they will have to go before the competent civil court. My lord, sir, I just cite one decision as to the what is the statutory authority that does in the matter of exercise of the rights conferred under specific statutes. My lords, 2002-5 SCC 685. There are 20 and 21, my lords. There are 20. On the arguments of parties, the question that arises for our consideration is whether the Election Commission, in exercise of its power under Section 29A of the Act, acts administratively or quasi-judicially. We shall first advert to the argument raised by the Land Council for the respondent to the effect that in the absence of any list or contest between the two contending parties before the Election Commission under Section 29A of the Act, the function discharged by it is administrative in nature and not a quasi-judicial one. The dictionary meaning of the word quasi is not exactly, and it is just in between a judicial and administrative function. It is true, in many cases, the statutory authorities were held to be quasi-judicial authorities, and decisions rendered by them were regarded as quasi-judicial, where there was contest between the two contending parties and the statutory authority was required to adjudicate upon the rights of the parties. In Cooper Wilson, it is stated that the definition of a quasi-judicial decision clearly suggests that there must be two or more contending parties and an outside authority to decide those disputes. In view of the aforesaid statement of law, where there are two or more parties contesting each other's claim and the statutory authority is required to adjudicate the rival claims between the parties, such a statutory authority was held to be quasi-judicial and decision rendered by it as a quasi-judicial order. Thus, where there is a list or two contesting parties making rival claims and the statutory authority under the statutory provision is required to decide such a dispute, and in the absence of any other attributes of a quasi-judicial authority, such a statutory authority is quasi-judicial authority. But there are 21, my lords. But there are cases where there is no list or two contending parties before a statutory authority, yet such a statutory authority has been held to be quasi-judicial and decision rendered by it as a quasi-judicial decision when such statutory authority is required to act judicially. In this connection, in R versus Dublin Corporation, it was held thus. In this connection, the term judicial does not necessarily means acts of a judge or legal tribunal sitting for the determination of matters of law. But for purpose of this question, a judicial act seems to be an act done by a competent authority upon consideration of facts and circumstances and imposing liability or affecting the rights. And if there be a body empowered by law to inquire into facts, make estimates to impose a rate on a district, it would seem to me that the acts of such body involving such consequences would be judicial acts. I have, my lords, referred to this precedent is that the statutory authority, that is the joint collector, what he will confine to the scope of the jurisdiction under Section 9 of the Pattadar Passbook Act and under 166B. Conferred by the respective enactments. My lord, if there is any excess, it is always open for them to, my lord, challenge such a decision. But they cannot prevent an order to be passed by such a statutory authority on the assumption that you are going to decide complicated questions of law or fact. When, my lord, prima facie, the property of Sultanpalli village is of Jagir. It is their burden
if at all, my lords advised to approach the competent civil forum, but they cannot challenge the subject notice issued. On the ground that you have no jurisdiction. My lords, absolutely, he has the jurisdiction. And if at all, my lords, they want to adjudicate any right, my lord, it is for them to approach the competent forum. I'm grateful, my lords, for your lordship.
Yes.
Since my friend referred to the Patta Passbook Act, section 12, your lordships may please note, which states that nothing in this act shall apply to lands belonging to the state government. And that has also been referred, my lords, in the order of the learned. Deeply obliged.
Mark the presence, learned advocate general, and Mr. Aditya Sun.
Subject to your lordship's kind pleasure. The one page which was, the one page where the portion was missing, may I just pass on a copy?
Yes,
They all
please,
sing.
I mean, not what, give the complete copy of the order.
It's a complete copy, my lords. I have
Yes,
specifically marked the page numbers for which the portion
Okay,
was
yes.
obliged. Obliged.
What is 44? Which this person is, you are 41. You said it won't reach. See, it has reached.
I'm obliged, your lordship.
No. Yes.
I'm also giving, filing written submissions, arguments, your lordship, for a kind consideration.
This one. See. What is it, madam, if you can tell in brief, not argue, because he has a right to argue. What is the dispute about? Why did he file the writ petition?
Challenge the award on the ground that the award must be last, but the associate compensation as sought for reference and the section. Just pending for other.
All right. Yes. Yes. All right.
Your lordship, before I begin, I will request the correspondents not to intervene, otherwise I'll.
She doesn't, we only wanted to, because she has a legally trained mind, so therefore, before hearing you, we asked her what is the matter about. There is nothing wrong in it.
Very well.
Because you will start that you were born in the year 1927 in a village in which Begumpet district, whatever district, Suryapalli district.
Your lordship, this judgment, this appeal concerns two issues, your lordship. Issue number 1, as per I have filed written submissions.
What is it? That's why written argument part 1, part 2.
Yes, yes.
And
If I succeed in part 1, succeed, I am in a position.
we only say that there is no part 3. Only 1 and 2.
Yes, yes. If I can convince this honorable court on the first issue in my favor, only then the question of considering second issue arises, Your Lordship.
Go ahead.
The matter contains only two issues, Your Lordship, as per single judge's order. Issue number 1, as per the order of the learned single judge at page number 10, right, whether subject proceedings has lapsed. This honorable court on 1/11/2017, only after having been fully convinced prima facie of the merits of the case that I have a watertight case, pleased to admit my writ appeal on the face of it. And further directed.
This is final hearing, Mr.
Yes, yes.
Now, don't go back to admission.
And further directed the respondent to file counter within 3 weeks from today, that is 1/11/2017. But no counter has been filed by the
Appeal, there is no counter.
Very well. As directed.
Rate appeal, which provision? There is a provision.
Very well.
No provision.
It was
just to argue on merits, right? Notification was issued on 20th 2007. Then 26/6/2007 declaration under section 6 issued.
Yes.
Then you filed a writ petition that was allowed, setting aside the declaration under section 6. With further direction to conduct an inquiry 5A. Thereafter.
Now I come to the point, Your Lordship.
That's why
Your Lordship,
everybody has to come to the point only.
now Your Lordship kindly take paragraph of the order. It says case boils down to 2 issues. If I can condition. Now coming to the first issue, Your Lordship, take page 14, para 11 of the order. It says section 11A of Act 1 of 1894 mandates of the award within 2 years from the date of section 6 declaration. Very, very true and correct. And exactly this is the crux of my case, Your Lordship. It further says, in the instance, section 6 declaration issued on 17/10/2014 afresh, pursuant to the orders of this court in WP number so also dated 2/1/2014.
Period of 2 years.
Now, Your Lordship,
We have understood, right? The declaration, the award has not been passed within a period of 2 years.
yes, Your Lordship. Your Lordship, exact declaration, it said in the instance case, section 6 declaration issued on 17/10/2014. Afresh.
Yes.
Afresh, pursuant to the order of this court in WP number 2/1/2014.
Land Acquisition Act, Madam. Land Acquisition Act. Yes.
Now your lordship may kindly take the order in WP number 2429.
We have understood, Mr. It has not, it has lapsed under 11A of the Act and single judge has wrongly held.
Yes.
But it did not lapse.
Exactly, your lordship.
So next point.
Next point, your lordship. Now your lordship may take page 15, para 16 of the order. It says it further clear in the counter affidavit of the respondent.
Publication of the declaration. It is within 6. This was 17/10/14. Yes.
Now I draw your lordship kind attention to page 3, para 12 of my written argument. Now your lordship may take page 15, para 16 of the order. It says it further clear from the counter affidavit of the respondent that the compensation is determined as per section 24.
Which part, Mr. Part 1, part 2 of
One only, your
page?
Page 3, para 12, your lordship.
Page 3. Yes.
One second point, as your lordship.
Yes, yes.
Now your lordship, it says it is further clear from the counter affidavit of the respondent that the compensation is determined as per section 24, reviewed section 20C, which is totally false and wrong, your lordship. The learned single judge clearly had to see that the mandatory provisions of section 26 and 27 have not been followed at all. What section 26 and 21 says? Section 26 says, provided also that the collector shall, before initiating any land acquisition proceedings in any case, take all necessary steps to revise and update the market value of the land on the basis of the prevailing market rate in that area. The collector, having determined the market value of the land to be acquired, shall calculate the total amount of compensation to be paid to the landowner whose land has been acquired, including all the assets attached to the land. The learned single judge totally has to see that the collector had not at all taken any steps to revise and update the market value of the land on the basis of the prevailing market rate as mandatorily required under section 26 and 27, had not at all been complied, which the learned single judge totally has to see. But on the contrary, your lordship, in spite of the respondents very well knowing that the basic minimum land rate, even according to the sub-registrar's office and even according to the respondent's own letter dated 2010-2013, was rupees 50,000 per square yard. But the respondents had the courage to pass the award 2015 at a mere rate of rupees 15,000 per square yard, your lordship, when the prevailing market rate of the land was 2 lakhs per square yard. And daringly saying, we have come.
Yes.
And daringly
what happened to the proceeding of reference you have?
And just let me. And daringly saying, we have complied with section 26 and 27 of the Act. And if the petitioner has any grievance to the quantum of compensation, it is open for the petitioner to agitate before the appropriate firm. Then, your lordship, the respondent could have very well taken the rate of 1,500 rupees per square yard and even then said the same thing. The lordship, respondent complied with the mandatory provisions of section 26, 27, Act 30 and revising and updating, illegally take away my land forcefully by using brute force, bulldoze everything, not even pass the award at the rate of minimum rate of 50,000 per square yard, being the minimum according to their own letter. And when the prevailing market was so with regard to the competition open for him to and about single judge totally have to see all and proving all these injustices and infirmities. And on the other hand, the Supreme Court says that private authority should pay the highest market price. In the evening of my life, the respondent.
Yes.
In the evening of my life, the respondents want me to run from pillar to post to get the fair market value of the land acquired illegally using wrong illegal means and did and enjoying the same since last 8 years, Your Lordship, without virtually paying anything substantial. The third point, Your Lordship, the learned thing is that further to take totally add in not seeing and noting the respondents.
Pregnancy.
Your Lordship, page 5, third point, 15.
Yes.
Page 5, paragraph first. The learned thing is that further totally add in not seeing and noting the respondents, apart from all the things and informative, respondents were resorting to and perusing the old lapse and repealed Act 1 of 1894. Even thereafter, again and again, on all occasions, even after 10 months, the lapse act by wrongfully issuing award inquiry notices under section 9(3) and 10 under LA Act 1 of 18 also on 2010-14 and again final award inquiry notice on 13/11/22, hence rendering the award totally wrong, illegal and void even on this count. Therefore, Your Lordship, I am of the firm conviction that this Honorable Court is fully convinced of the issue number 1 in my favor, and now I draw Your Lordship's kind attention to issue number 2, part 2. Now, Your Lordship, issue number 2, as per the order, as per the order of the learned single judge at page 10, whether the petitioner is entitled for damages claimed. Your Lordship, as I have fully convinced this court on this first issue in my favor, therefore the reasons for claim of damages of 20 crores are as follows. Your Lordship, no action remains since 25/5/2009, and even then, forcefully taking a possession of using brute force and bulldozing heritage first property 27/3/2015. For entirely following the repealed and the lapsed Act 1 of 1894, even after 1/1/2014. For not following the mandatory provisions of law, the LA Act 30 of 2013, even after 1/1/14, and all its mandatory provisions right from section 8 to 30, and subsequent illegal awards. For the failure of the part of the collector for not taking necessary steps to revise and update the market value of the land on the basis of the prevailing market rate in that area, as mandated.
Don't read it here. We will read it already. You have given.
Passing the illegal award at 15, or not passing the award at 15, even at the minimum rate of 50,000, which was the minimum. But for all the subsequent consequences, with all the physical and mental torture and agony and pain faced at the time of illegal acquisition by brute force, resulting in I and my entire family being thrown on the road. Our gate compound was bulldozed all of a sudden, even without notice. Our water connection was disconnected for 2 weeks. We had no water even to drink. We had no passage to leave the house, even on foot, even for emergency purposes, even to go to hospital or a doctor, as our heritage property is located on a higher level, and by taking away 665 square yards of land, we got completely cut off from the road, and we were 6 to 8 feet on a higher level. In spite of all of our family members, ladies and gentlemen, being senior citizens of 70 to 80 years of age, my entire garden, beautiful raining, great pillars of heritage importance, fountains were all destroyed and bulldozed, which all formed part of the heritage. We had no component for safety and security of life and property for 2 years. We were all living like a railway platform with risk, with full risk for our life and family and property. And the most important of all, our reputations of 7 generations shatter, Your Lordship, which no amount of money can compensate. We are all shell-shocked, do not understand what has happened. Now, Your Lordship, for the mental actual agony and pain being faced by me from the last 8 years to get the fair market value of the land illegally acquired by 8 years. I have given account how 8 years have been passed for no fault of mine, Your Lordship. Your Lordship will understand how people are suffering. Your Lordship, first it took more than 2 years for the government to form this LA authority. This authority was formed only on 8/3/2017, after 2 years, Your Lordship. Then it took more than 2 years for the respondent to get the file from the district and send it to this LA authority, Your Lordship. 4 years passed. Then it took more than 6 months in the usual court procedure, that is numbering of the suit notice, etc. Then it took 6 months in shifting this LA office from PRK Bhavan to present Namkali Station Road. Then it took 6 months in the presiding officer and GP's term expiring and renewal. Then it took 1 month, 1 year in which, then from last 6 months, 1 year, only adjournment to 2 months, nothing is happening. Like this way, Your Lordship, from 8 months, I am running from pillar to post.
No, you came before us on 31st of August. We allowed.
I am against this honorable court. Lordship have been so.
And we allowed.
Have given me a patient hearing, have given me everything, irrespective of this.
Yes.
Have been so kind of courteous to me. It is as it is
20 crore damages should be given.
It is called in legal parlance. This is one of the rarest of rare cases. And to meet the ends of justice to some extent, I pray this honorable court grant 20 crore and damages for the several wrongdoings and illegality committed by the respondent as narrated by me in detail above. It is therefore prayed that this one will be close one. Award a sum of amend the award dated so and so from the present 15,000 to 50,000 rupees per square yard, being the basic minimum rate according to the sub-decided and even according. Further direct to the Land Acquisition Rehabilitation Authority, where the case is pending under section 64 and is numbered as so and so fair market value, and to complete the case within a maximum period of 3 to 4 months, taking into consideration highest land rate any area of the Twin Cities, as this may command the highest market rate in any other area of the Twin Cities, Your Lordship. As no sale instances, Your Lordship, how will you judge? We have to give sale instances. As there are no sale instances in the bigger area, no sales have taken place during that period. Before I found out, madam, we found out, Your Lordship. And even as collector has failed to revise and update the rate as per the prevailing market as mandated under section so and so. Post the writ appeal after 3 to 4 months to record compliance of the orders of this honorable court.
No. We will not post it. We will decide it.
No, your party order is keep it pending, Your Lordship.
No. It's not done.
You will not comply.
You will.
Sit on the order, Your Lordship. They will
We
sit
don't
on
know
the order.
whether they will sit or not. Contempt then. Yeah, all right. That's it. Thank you. Thank you for being brief and precise. Brief and precise. Thank you.
I have to be.
Yes, madam.
Thank you, Lord, for giving me a patient hearing. Much obliged. Can I sit down, Your Lordship?
Of course. It's chairs are meant for you only. Yes. Please sit down. Yes.
Compensation.
Under protest, he can receive. No.
Yes, definitely.
Last year I have received the
Now same rule applies to you also. That when she speaks, you don't speak. She did not speak a word, right? Now don't speak. Yes.
Wherein he received the compensation and also filed a claim petition for seeking
Under protest. Under protest.
yes, under protest, and then he saw
That he has a right.
section 64.
No, madam,
For
that is
reimbursement of compensation.
his statutory right.
Yes,
That is statutory right of any person whose land is acquired to seek a reference for enhancement of compensation. You cannot say that he has filed it. Why he should not file? Anybody will file.
on one parallel, my lord, seeking a one enhancement of the compensation and seeking a relief to set aside that award cannot be gone with.
No, so that you want that his remedy should be time barred and then you should say that no, you can't seek.
It's not a time bar. It's not a time bar, not because
we have understood, right? We have understood that he could not have sought a reference. Therefore, his reference should be dismissed and writ of appeal should also be dismissed.
Not only that, my lord, there was a stay by this honorable court under section 11A, my lord. Under section 11A of the old act speaks that,
Right.
11, lordships may kindly see 11A explanation. In computing the period of 2 years, my lord, the period which an action or proceeding has been stayed, then the.
So do you think that we have not read the 1894 Act and for 30 years we are just like this, 11 years? Oh, everybody knows that for computing the period of stay shall be excluded.
Yes.
The award has been passed within a period of 1 year from the date of issuance of declaration, madam. What are you arguing? We don't know.
It's been passed, there was a stay, my lord, and the petition has been pending. Thereafter, after the allowing of the petition, it has been passed within a 1 year, my lord. After dismissing of the petition, it has been passed within a 1 year. I'll give the dates, my lord.
Did we say that it has been passed after 4 years? The learned single judge has recorded a finding, madam. We have read it. Para 11. Para 11, single judge has recorded a finding.
They are within time. Are they within time?
Oh.
It's in case of issue to place. No, period is within this declaration. We should within 2 years the award has to be passed. Then subsequent finding. Right, so I thought to say that it is not applied.
Para 11, my lord.
After 1 year, it's changed. It's 11, it does not apply. It's not apply.
Paragraph 11.
Hey, we have read it, madam. What are you?
Nothing, my lord. I'm only stating that it's not in the judgment. It's not stated that it's vitiated.
Yes. Anything else, madam? Anything else? Para 11 we have read, no?
Yes.
If you want to read it, read again. We have read it. For your satisfaction, you may read. Yes.
In this, my lord, the section 6 declaration has been issued on 17/10/14 and in view of the orders dated 2/1/2014, my lord, and thereafter 5/2/2015, the award has been passed. Hence, it's well within time. Because before that, a stay has been granted. And as per section 11A, any stay granted has to be deducted. That period has to be excluded. As per section 11A of the old act.
What about non-compliance of section 26 and 24? That is also argued by him.
Then I'll take.
You are reading the obvious.
Then I will take your lordships to the award, my lord. It's page number 68. It's passed under the new act itself. 100% solatium, additional market value, everything has been done, has been given as per the new act itself. That he has not stated, my lord. It's an incorrect argument made by the party in person, my lord. Because at page number 68, clearly shows, my lord, page number 69, the abstract, my lord, wherein it clearly shows how the market value has been arrived and the 100% solatium has also been given and the additional market value. In the old act, there is no 100% solatium. Then how can they say that it has not been taken into account? The new award has not been passed as per the new act, my lord. For a moment, your lordships may kindly see page number 69.
2013 Act. And looking forward to why I'm having a 9997 petition I want to hear. Not understanding. Anything else, madam? That's all?
Yes.
Yes.
Your Lordship, what the learned counsel is representing is totally false. So
That's obvious.
Your Lordship may kindly look. Your Lordship, Section 6 notification was first issued on 25/5/2007.
So from 2009, the award should have been passed according to you.
There was no stay in 12429, only notice was ordered. Your Lordship can, I have written on page. Your Lordship can check the records. There was no stay being wrongly being argued. Now number 2 issue, he said that award, now it's computed at section as per section 12. He's taking the rate at 15,000. That just manipulating, cheating the people. We are paying 100%, taking the rate at minimum 1,500, 2 lakhs instead of 2 lakhs, taking the rate at 15,000, paying at double. And then saying, sir, we have complied with section 24. Is this compliance, Your Lordship?
That we will answer in the judgment. If we don't answer to the questions posed to us like this. Yeah, all right. You have argued very well. Yes. It's time for you to be in peace with yourself and not agitated, right? This part of the life, what you need most is the peace, not litigation. We will decide this appeal.
My Lordship, but 2 minutes. I am only one son. I lost my daughter-in-law by cancer 2.5 years ago. My son is totally not unable to bear with the loss. I am all alone, Lord. What can I do? But the difference is that.
Anything else? That's all. Party in person, writer name, arguments heard, reserved for delivery of judgment. Yes.
On the judgment, my Lord, your Lordships may, one judgment I would like. AR 1997 Supreme Court 2426.
Write down 97, so 242. Yes. What is this after? You should have said in the beat. Yes. What is this 97 petition, Mr. 99?
This was that case, Lord, your Lordship heard it on last occasion with regard to construction of a commercial complex, my Lord, in a park. It was demanded from Supreme Court.
Yes. Sorry, we were looking, we wanted madam to hurry up because we were looking up 99 and 97 petition.
My Lordship, before, sir.
Yes.
Before submission, my Lordship.
No submission.
My Lordship,
nothing. Please, for the petitioner, don't seek adjournment. Yes.
Adjournment, my Lordship. I would like to bring to notice of this Honorable Court that respondent number 8 of the petition has been died, my Lordship. That is only.
That doesn't really matter.
Doesn't really matter.
He's not claiming the rights in the property. He's sold it off to 4 and 5.
Lord, respondent number 7.
Delete the name of respondent number 8. Now, no ground to elect for adjournment.
Just to bring the notice of this Honorable Court, my Lordship.
Otherwise, it would have been again remanded by the Supreme Court. So nice. Mark the presence. You have
filed a memo to the effect, my Lordship.
You have filed a memo.
Yes, my Lordship.
Learned, what's your name?
Ravindra Reddy, my Lordship.
Mr. Ravindra Reddy, Learned Counsel, has filed a memo 2001. 168. Book. Yes. Yes, Mister. What you have to delete? Delete it.
No, I'm just trying to locate the affidavit, my lord. This writ fiction.
At the beginning itself, I believe. Beginning we saw the cost title just now. I don't know whether it's. Hey, Mister, how you?
Writ fiction, these delete chips.
They are required to delete it, the petition. Affidavit you won't touch. Fiction is it. Fiction.
Read petition.
The background fiction or fiction opinions. Fiction. Correct.
Ah. So your submissions, yes, Mister.
Not
This brief note you have given, right?
yes, my lord. That covers, my lord, most of the issues. All the issues, in fact, reference to the paragraph in the pleadings also. The land, my lord, was acquired not for purpose of Indian Airlines employees, and the layout, my lord, was approved by the Urban Development Authority. And Urban Development Authority, my lord, handed over to AP Housing Board for development of that particular area. My lord, in the process, my lord, R7 and R8, respondent number 7 and 8, my lord, acting on behalf of AP Housing Board, executed sale deeds, my lord, with reference to this scheduled land in favor of respondent number 5 and 6. My lord, when we filed this writ petition, my lord, the defense that was taken was consistently, my lord, by all the respondents is that the land which under the original layout was a park. Subsequently, AP Housing Board had altered the plan. On the basis of that, these plots were sold to respondents number 5 and 6. In the earlier round of litigation, my lord, in the first round, my lord, this court, my lord, considered the scope of the Housing Board Act vis-a-vis, my lord, the Urban Development Authority Act, and my lord, considered the fact, my lord, that the Housing Board does not have any power to alter the layout. On the basis of that, my lord, the court, my lord, passed an order directing demolition of this commercial building, my lord, which was constructed there. The matter was carried to Supreme Court. Supreme Court, my lord, remanded it. Though no explicit reasons have been mentioned, my lord, for this reasons for
You agreed. That is the reason that counsel for petitioner agreed for remand. So your submissions are that the land is earmarked for park, no commercial complex would have been constructed. Second is Huda has not altered the layout, permitting it for any other use. AP Housing Board has also no power to alter the layout, and it's a case of tampering with the original layout prepared by Huda. And according to official respondents like APSC, MCH, and Huda, also this is a park.
Yes, APHP, my lord, had filed its counter, saying, my lord, that the layout has been tampered with, and that is not the original.
Which paragraph they've said? APSC. Whose layout? Whose counter?
My lord, APHP's counter.
Point number 2.
Ah.
My lord, while the writ petition was pending, my
Which
lord,
paragraph? Respond number 2's counter, which para? They said it is altered.
Page 109. My lord, this is the statement made before the inquiry officer, my lord, appointed by this court during the pendency of the earlier writ petition.
(109). Reply affidavit of petitioner.
Page 10, my lord, in the original paper, there were two paper books. Page 108, statement on behalf of respondent number 2 in WP 25738. Court officer. Pink book. Pink.
Statement. Ask him.
109.
108.
108.
108. You are referring to 108.
108.
There is an acknowledgement of receipt of check. Are you referring to that?
No. This is, my lord, a statement made by the respondent number 2 before the inquiry, my lord, inquiry officer appointed by this court.
Okay. Statement made by
respondent number 2.
No, who is the respondent number 2? There has to be some. Housing Board cannot, some officer must have.
Yes.
Which person? Statement made by
the executive engineer.
Ah.
J.G.S. Ramarao.
Executive engineer of Housing Board.
Yes.
In an inquiry before
the inquiry officer appointed, my lord, by this court to determine the question whether this particular land is a park or not.
Which order? Order dated?
One 2000. 18.
I order dated
1st August 2000.
2000. Yes, you are referring to 108 page. What is the name? Says Mr. Venkateshwar Rao.
I have one book. Thanks. We filed.
Statement like it, the document reads like this: statement on behalf of part 2.
Yes,
Right.
precise. There, my lord, your lordship may come to para 9 onwards, para 7 onwards.
Para 7.
Yes. As seen from the layout sanctioned by Huda and as submitted by APHP to Huda, the area in dispute is earmarked for park. The details in the reference shown in the plan number 1 are as follows. Then, my lord, para 9. In the plan available in the files of APHP, blueprint plans, this particular area is shown as park. However, there is only one plan on the tracing paper which is signed by Junior Housing Engineer, District Housing Engineer and Regional Housing Engineer of APHP on 10/4/1987. However, in this plan, the particular area is shown as S1 and S2 shops. It submitted that when a copy of the revised layout was sought, the copy of the same was furnished to various authorities by officials of APHP believing the same as the revised layout. A copy of the same is annexed herewith as plan number 2. But on a close scrutiny of the plan now, it has come to light that said plan has been tampered with and the words as shops S1 and S2 have been subsequently interpolated. Moreover, the said plan is not correct for the reason that the said plan shows the total area allotted as 15.9 hectares and the total area of the site as 69,570 square yards. In fact, the area acquired is only 12 acres 24 guntas. The details of the reference of the area shown in this plan are as follows. Para 10, as seen from the above para, in fact, the references in plan number 2 do not tally with the area actually acquired and in possession of APHP originally. Further, the word shops 2 numbers also appears to have been interpolated in references. However, a copy of plan number 2 was furnished to the authorities by mistake bona fidely on 31/3/99. In fact, this is not the correct one as approved by APHP on 10/4/1987 or the one which was approved by Huda. This has been their consistent stand. My lord, in the counter affidavit, in fact, they have explicitly explained this, my lord, in the counter filed in the Supreme Court. My lord, in the additional papers, my lord, which I have filed in 2007, along with, my lord, IA, the WPMP 10336. There, my lord, at page 42 to 54.
You are appealing for respond number 2.
5 and 6, my lord.
5 and 6. Who are 5 and 6?
They are the owners of the property, my lord. They have purchased the property from 7 and 8, my lord.
Okay.
They have not.
Sit down, right? Sit down, relax.
Page 42, my lord, is a detailed counter.
This is before Supreme Court, right?
This was filed, my lord, before Supreme Court. At the time, when they filed a counter in this writ petition, the counter was not very explicit. Now, my lord, in this inquiry report and in the counter filed in the Supreme Court, they have explicitly stated, my lord, all these facts. Lordship may see para 5. Because in the inquiry report, my lord, opined, conducted, not at the instance of this court, my lord, it was held that the land is not a park. With reference to that, my lord, para 5. para 5, para 10, 11. Not are with regard to
Yes.
this is the stand, my lord, of APHP. Now,
What do I have said in para 5, 10, 11?
may I read, my lord?
No, you can tell us what they have said.
My lord, they have reiterated, my lord, what was stated, my lord, before the inquiry officer, saying that there has been an interpolation and my lord, that the plan was originally earmarked as a part, my lord, in the layout approved by Huda at the first instance. Therefore, this para 5, 9, 10, 11 may not speak of this particular fact.
Yes.
Then, my lord, the other authorities, that is the MCH, which has approved the layout, they also filed their counters, my lord, reiterating the fact that since the plan was furnished to us by APHP, we had approved the plan. We had approved the building plan. But however, an undertaking was taken, my lord, from, in fact, the respondent number 7, who has executed the sale deed in favor of respondents number 5 and 6. My lord, on behalf of APHP, my lord had applied for the plan. And when MCH, my lord, sought undertaking that in case in future it is known that it is a part earmarked for part, plan stands cancelled. He has given his affidavit, my lord, to that effect. And the building plan was approved, my lord, only in that context. The MCH, my lord, also reiterated the fact, my lord, that originally the plan was earmarked for part, and we had approved it on a mistaken notion that the layout was revised by APH. This is the stand, my lord, which the MCH has. Now, Huda also has filed a counter. Huda, my lord, which is the Urban Development Authority, which has initially sanctioned the plan. My lord had filed a counter, my lord, at page 67.
This is which page? Now this compilation.
Not the original paper book, my lord, the initial paper book.
Not this.
Not.
67. Yes.
Para 2.
Yes.
My lord, I am reading last 5 lines. It is submitted that after perusal of the petitioner's affidavit, it is observed that the site under reference is earmarked as park in the sanctioned layout, which is in favor of Indian Airlines Housing Colony at Begumpet. As the area falls within the jurisdiction of MCH, and the Commissioner and Special Officer MCH is the competent authority to permit any building within its jurisdiction and to take any action on the buildings which are constructed against the rules and regulations. It is submitted that the site under reference is a park, and the MCH is the custodian of those areas earmarked as open space park within the layouts, and as such there is no role of Huda to initiate any action against violation of unauthorized constructions taking place within the jurisdiction of MCH area. They also say they don't read, they also say, my lord, that they have not revised the plan at any point of time. Because the stand, my lord, of respondents number 5 and 6 in the petition is that AP Housing Board has revised the plan. Your lordship, we have to see their counter, not which is at page number 73. In the middle, my lord. In the revised layout of the Andhra Pradesh Housing Board, the plot
73.
74, my lord, I am reading about
1 minute. This is what
Tenth line.
enter affidavit by 5 and 6.
5 and 6.
Yes.
Tenth
Revised
line.
layout.
In the revised layout of AP Housing Board, the plots S1 and S2 were earmarked for shops as they were at the entrance of the colony. The space meant for park and community hall shown in the layout plan are maintained and handed over to municipal park. The instant plants were never used as park, nor they were reserved for park in the revised layout. But this is their stand.
Yes.
So the consistently, my lord, the stand is that there was in a revision, and the revising authority disowns the revision, saying that there is interpolation. My lord, says that we have not reapproved any modified any plan. My lord, the Housing Board is also a creature, my lord, of a statute, 1957 Act. And my lord, Urban Development Authority, my lord, is created under 1972 Act. Both are state acts. My lord, these two issues, my lord, both have non-obstante clauses. My lord, in the earlier these issues, my lord, were considered, notwithstanding, my lord, the factual allegations which have been put across. Since APHB does not have any power, in fact, that is their stand also.
Yes.
In fact, that is their stand also. My lord, this court held that APHB does not have any power and therefore, my lord, directed for demolition. Notwithstanding any factual allegations, my lord, which have been made vis-a-vis the functioning of the Indian Airlines Society, my lord, between the petitioner and respondent number 7 and 8. Notwithstanding that, only on pure legal question, my lord, this court held. Other aspect, my lord, which the court bench, my lord, held was that, my lord, the sale deeds, my lord, in favor of respondents number 5 and 6, my lord, were executed by respondents number 7 and 8 on behalf of AP Housing Board. And respondent number 7 and 8, my lord, are not employees or any officers, my lord, concerned with APHB. They are, my lord, the members of Indian Airlines Society. They execute sale deed, my lord, on behalf of APHB in favor of respondent number 5 and 6.
So, your submission is that R7 and R8 had no authority.
This court, yes, R7 and R8, my lord, had no authority
to execute sale deed on behalf of
AP Housing Board.
R5 and R6.
And the stand, my lord, of APHB with regard to those sale deeds is that they have never authorized and they are void. That's their stand, my lord, which they have taken. In the additional counter affidavit, my lord, filed before Supreme Court.
Where?
Vice Chair. And everyone is followed by Vice Chair. Page 42.
Lord, the counter in Supreme Court, Lord, as my friend has pointed out.
You said additional counter.
Yes, I'm sorry. Additional counter.
Page?
Not the same one. Page 42, my lord, in the additional papers, my lord, which I had filed.
Yes.
My lord, was filed by the Vice Chairman, my lord, of APHB.
Oh, Vice Chair. Yes.
The observations, my lord, they stand with regard to the plea with regard to, my lord, the sale deeds is at page number 47 and 48. So there's no paragraphing, my lord, it's a Not from the middle of the.
No, we see, Mr. We cannot go into legality of the sale deed and quash it in under Article 226. This SP Anand is directly against you. If you are seeking declaration that the sale deed is void, you file a civil suit. We are only in this public interest litigation where the scope of inquiry is whether in respect of an area earmarked for park, a commercial complex or shops have been constructed. So there's no point, right, that sale deed is void. Maybe so. You can file civil suit, seek a declaration.
I'm only covering, my lord, all the facts which have been urged and considered, my lord, in the earlier round. And they were not.
We will not go into this question of validity of the sale deed. We are telling you. It's not SP Anand you have read, right? SP Anand, what does it say?
Civil court.
The court in exercise of power under Article 226 has no power to declare a sale deed invalid or void. We don't have that power. Anybody, if he says so, we don't know. Yes.
But my note, my lord, have exhaustively detailedly mentioned, my lord, all the dates.
Yes.
And my lord, the pleadings with reference to the page numbers and the paragraphs. It has, though the case law needs to be updated, case law, my lord,
you're relying on the post remand like this thing.
True, but that
post remand that's to update it. You still stuck up in 91 volume 4 SSC 54.
But that was a note.
Much water has flown. 12. 2012.
I prepared it in 2012. Now I'm getting a chance.
No. But see, we heard you on earlier occasion also.
True.
Thereafter, you got sufficient time of, I believe, more than 10 days. You can update it.
Well, I'll pass on.
Tomorrow. We'll hear Mr. Prabhakar. You are appearing
for the board.
AP Housing Board. You are what is your stand?
Stand is we are supporting the petitioner.
All right.
But what had happened is, as my friend was pointing out, he missed out page 44. Your Lord.
So shall we continue tomorrow, Mr.
It will
Prabhakar?
take more than five minutes.
Okay.
So, page 44.
Page
44 of the additional booklet that he has passed on. Pointing out about this.
Why do you stand up every time? Relax, your turn will come. It can't be decided without hearing it. Yes. Yes.
But paragraph 5 at page 43, it begins, but we don't have to read the whole thing. Just for continuation, particular portion.
Yes.
The writ petition has also before the expiry officer. Last line. That a particular portion of the plan has been tampered. Besides various other reasons given in support of the tampering, it will also specifically point out that the AP Housing Board never mentions the commercial space as S1, S2, as is figuring in the present layout. The commercial space would be shown as commercial purpose in the layout. It is also noticed that there is difference in writing of S1, S2 and shops, and there is also interpolation of the words area acquired in the reference column, and the particulars were marked before the inquiry officer. This fact was spoken to by the executive leader of the Housing Board, who was examined as a witness before the inquiry officer. As regards the allegation para 5C of the SLP, it is submitted that as a matter of fact, there is no revised layout as approved by HUDA. Now, this is important. Whether there is a revised layout or not is the issue. Then at page 45. The details of the reference shown in plan number 1 are as follows. Total area of the site 60,000, area under plots 35,009, area under plots in open 6182 square yards, area under roads 18,202. That is how the total worked out to 109 plots. And B type plots 159. In the plan available in files of APHP, the particular area shown as park. There is one plan on tracing paper which is assigned by Junior Housing Engineer, District Housing Engineer and Regional Housing Engineer on 10/4/87. But this plan, this particular area is shown as S1, S2 shops. It is also submitted when a copy of the revised layout was sought. The copy of the same was furnished to various authorities by officials of APHB believing the same as the revised layout. A copy of the same is annexed here with the plan number 2. However, on a close scrutiny of the plan now, it has come to light the said plan has been tampered with and the word shops S1 and S2 have been subsequently interpolated. The said plan is not correct for the reason that the said plan shows the total area allocated is 15 acres 19 guntas and the total area of land is 69,570. But this is how this tampering has happened. The only acquired area is 60,000. And what had happened was there was some collusion between the staff and the, as it usually happens. That's what happened. Then that another aspect is the sale deed makes an important, very, very interesting reading. Your Lordship will see, just for the sake of, that is where not that we wanted to declare to be void. One sale deed sample, Your Lordship will see how it is executed. No, it is there. I'll give the same. Page 148. Fortunately, now there is a span there. This sale deed executed on this at page 148. Rangareddy district, Hyderabad, the Andhra Pradesh Housing Board, Rokalpa, MJ Road, Hyderabad. But your Lordship will, anybody who looks at it will get a feeling that Housing Board is executing the sale deed. Represented by its chairman, again, Mr. Harinath.
This officer R7 and R8 have executed with the authority.
Yes.
On behalf of the board to execute that point.
We are on that ground, we are not seeking for a declaration that is void. But how the part is played? Just to buttress that aspect. Right.
That's it.
It's a public property, we'll have to say.
Yes.
So it's the only anxiety. Otherwise, because yesterday I was shopping. They were saying we don't get anything out of this. Our clients were instructing me, but I said that it's a public property. We have
yes, definitely. For generations to come, future generation, not for us.
See the overall layout, my friend can see. That aspect was missed in earlier judgment. The two that now I have pointed out the figures. 60,000 was available. Now suddenly in the revised layout that they say 69,000 just to keep this as shops. That also.
You are appealing for Mr.
But
you will have a occasion to make rejoinder submissions also.
I just wanted to point out, my lord, at page 20 of the additional papers, is the stand, my lord, additional counter affidavit, common counter affidavit filed by MCH, not before Supreme Court. Their stand, my lord, is that they came to know that the land is a park only after the requisition was filed.
All right, that's it.
And they stand, my lord.
You are appealing for
station.
But
in this case,
you are opposing the petitioner.
But in this case, the stand taken by the municipal corporation on behalf of the.
No. Are you supporting the petitioner or opposing?
Supporting, because we granted the building permission. We undertaken the taken from the party saying that if any irregularity is noticed, permission will be cancelled. That is an undertaking given by them. And later on, in the counter itself is clearly stated, this case is anti-corruption bureau booked the criminal case against this layout. Because the reversal layout and some layouts is there, that's what the entire file is seized by the anti-corruption bureau. That's what that.
All right.
Page 20.
You appear for respondent number what?
Municipal administration. GP for municipal administration.
One aspect. Lordship may also consider, my lord, page 20.
See the time, right? He will have to be heard. We cannot compel him to argue now. 4:45. So he will have to be, we are posting it tomorrow. It's not that we are closing. You will have, we said in the beginning, you will have a right to rejoinder what he argues subject. We are not closing it. Further hearing. So one case we were told that you made us argue after 4:30 and passed an order. in one case where a stay was modified, the council said that you made us argue beyond 4:30 and passed an order. This is the charge we are conscious, right, of whatever is told to us. So we cannot, he will say that first ground SLP 4:45 court pressurized me to argue and concluded without hearing me. 99, this is pending. Our anxiety is only to decide. Nothing beyond that. We don't know what is the subject matter, where is it located. I can say for myself for sure, 100%. I from my residence to court and court to residence. In between, I know that Ambedkar statue and this thing and Hussain Sagar Lake. That much of Hyderabad I know. And I see Hyderabad metro also. We don't know where is this building. So, right?
From this side also we can ensure that we not make such a. I don't think my friends also would like. Maybe some have some.
Yesterday itself, the council himself had appeared in that case and he filed a fresh petition and he was arguing, he said that after hearing him, we modified the order. In earlier petition, he said that no, I am being criticized for getting this order, so I should argue again and your lordship should take a different view. We said that we have modified the order. It is subject to SLP. But so we had to hear, brother knows. That's why we are telling you, you will be heard, right? It can't be closed without hearing you. Nobody can close it. So while you are trying to tell us in bits and pieces, please keep it for rejoinder submissions and tell the whole 1, 2, 3, 4 points. Yes, mark the presence.
They were making is sometimes the council may think that after 4:30 our matter would not taken up and leave the.
No, we don't want. But this the submission made, his was made. Did he not say? Did he not say?
Yes.
Did he not say that it was made in open court that after 4:30? That's why.
Maybe they thought 10:30 tomorrow the view of the court may change.
This another case is council is not appearing, Mr. Siddharth Sharma.
Appearing for.
My friend is here.
43. What are the petitions? I think number 40.
What do you say?
I'm adopting the arguments of.
That's what you are suffering from conjunctivitis, right? Fine. Okay. So 42, 43. We have to see that another remand doesn't happen. No, for that we are extremely cautious in recording order sheet also. 42 and Mr. Prabhakar, learned senior counsel for respondent number 2, MP House, whatever, AP Housing Board, and Mr. GP for Municipal Administration have concluded their submission. However, on account of line below, however, on account of paucity of time, submissions of respondent number 5 and 6 would not be heard. List for further hearing tomorrow. And then 43, Mr. Siddharth Sharma, learned counsel for the petitioner, has concluded his submissions. You also there.
Second respondent.
Respondent number 2. You are there, not there. In his petition.
Second petition.
Housing Board and Municipal Administration, same order, have concluded their submission. Item 43, Mr. List, however, on account of paucity of time, submissions of respondent number in your petition, Mr.
5 and 6.
5 and 6.
Parties in my petition.
That
The fifth party is the Indian Airlines Housing Society in my petition.
submissions of, however, submission of other respondents could not be heard. List for further hearing tomorrow. Separate order sheets, right? 42, 43. Tomorrow it will come up. As soon as motion hearing comes.
But I was there when the remand was made. I can speak.
We were wondering what happened to them.
The Supreme Court gave 2 choices. Supreme Court said we'll grant leave and keep the matter pending because some additional documents were filed. And they said ultimately it will go back for, instead, the High Court will dispose of within a year, you better go back to the High Court.
Oh,
So we thought that's a better thing.
better off.
Then I was representing the Housing Board as a standing counsel. Yes.
Oh, that was really. So, but you realize that probably you made a mistake.
Oh.
This is lighter win, Mr. Professor. What can we say at
That, in fact, that person I argued, 2012 civil appeal, day before yesterday in the Supreme Court.
Yeah.
It's better than retrospect. I was thinking that we have taken a good decision. At least.
Okay, thank you.